25.
As of today, Lordship, we need some accommodation, Lordship. The conducting counsel, Mr. P. Das, he had to move out of station due to some personal emergency. Let it come day after tomorrow, Lordship. Just accommodation for a single day I am seeking, Lordship. He is otherwise out of station, Lordship.
Mr. Gogol?
কিবা personal কামৰ কাৰণে বাহিৰত যাব লগা হ'ল।
Council's personal difficulties, I have nothing.
No, otherwise,
Matter is very urgent.
yes, that we also understand.
Only that put on our work is proceed.
Only for 2 days.
No, therefore, we have listed the matter today.
But the when lordship, that Sanskrit college, they have also lordship backward, they have done lordship. Even also they have also cleared that.
For a single day, let it come day after tomorrow, Lordship.
Mr. Ganguly, learned counsel, appearing on behalf of Mr. P. Das, learned conducting counsel for the petitioner. Press for listing the matter day after tomorrow. As Mr. P. Das, learned conducting counsel is out of station.
Tomorrow lordship, tomorrow.
Tomorrow.
Will be difficult. If he has no objection on Friday,
Tomorrow, tomorrow.
কালি আহি পাব। Tomorrow possibly he is coming in, he will be reaching by 2, Lordship. Maybe difficult. Then if he has no objection, then on Friday, Lordship.
Yes. Friday. Interim order pastoral cell containing. The matter will be listed under the column admission.
Yes, already we have served copies. A interim order is there, that may be continued.
Yes.
Came is the part of this because my heart is playing.
Yes.
Okay, let's just list the matter as parted.
Friday. Problem.
Come in motion tomorrow.
No, admission. Notice already issued.
Yes, we have already served copies.
My lord, I have filed a RSA, my lord, a civil revision petition. Kindly matter may be listed, my lord, 27, my lord. That is urgent matter, my lord. 27,
Okay.
highly obliged, my lord.
Guidance for orders.
We take the lordship is illegal, like in another court, lordship may kindly fix this matter too.
Who is your senior?
Lordship even that lordship until administrative tribunal near lordship Board service. So lordship.
Yes, Mr. Das. At 2 o'clock.
And then it was 7.
None appears for the applicant on call. Applicant is for appellant on call. None appears for the respondent also on call. Respondent opposite party also on call. List the matter after a week. In the event of subsequent non-representation of the applicant appellant, the appropriate order shall follow.
Give 8.
May I please, your Lordship, we have to take steps on respondents.
through paper publication. We could not trace the applicants. However, he approached today. We'll take steps.
Lordship, the 2010 medal, Lordship, earlier several dates are adjourned, Lordship, for publication of the newspaper. Lordship. The RSA dismissed, Lordship, on default. Lordship. 2010 medal, Lordship, the land was owned by the applicant, Lordship. The titles were dismissed, title of the.
Okay.
Lordship, last
Heard,
words.
Mr. Your name, please.
P. Sharma on behalf of R. Chakraborty.
Learned counsel appearing on behalf of Mr. Chakraborty, learned conducting counsel for the applicant, and Mr. N. Ahmed, learned counsel for the
Applicant. Respect number one.
respondent number 1. Office note dated 21/2/2026 indicates that no step has been taken upon the respondent number 2 by way of paper publication. The learned counsel for the petitioner, applicant submits that he may be granted some time to take step upon respondent number 2. Fair allowed, recessal is the matter. After 2 weeks.
Date may be fixed.
Okay.
On 13th March. Number 10.
We have not been served copy of your folder.
Pardon?
Not been served copy of the petition.
Not received.
Not this. The folder respondent number. One. Lordship, I will serve. And as regards to LCR, Lordship, it has been received here. Should make it for hearing.
LCR has been received.
Yes, Lord.
Heard, Mr. Your name, please.
A Bhuya. I'm appearing on behalf of Mr. N.
The appellant and Mr.
Zaid Islam, Lordship.
Zaid Islam, learned counsel for the respondent.
One.
Learned counsel for the respondent submits that he has not been furnished with a copy of the memorandum of appeal. The learned counsel for the appellant undertakes to furnish a copy of the memo of appeal to the learned counsel for the respondent during the course of the day. During the course of the day. It appears from the office note dated 20th/2/2026 that the records of the learned trial court and also of the appellate court has been received. And in that view of the matter, it is provided that recessal is the matter for hearing in usual course.
Obliged.
And number 12.
May I please, your Lordship? Lordship, as per office note dated 17/1/26, Lordship, service completed upon respondent number 12345, Lordship. And as per office note dated, Lordship, 21/2, Lordship, service not completed 6 and 7, Lordship. So my prayer, Lordship, respondent number 6 and 7 are not necessary party. They may be, their name may be strike out, Lordship, and fix the matter for admission, Lordship.
Okay. Heard, Mr.
P. Sharma.
Learned counsel for the petitioner. Office note dated 21/2/2026 indicates that service upon respondent number 6 and 7 are yet to be completed. The learned counsel for the petitioner submits that respondent numbers 6 and 7 are not necessary party in this proceeding, and as such, their name may be struck off from the array of this petition. Accordingly, taking note of the submission of learned counsel for the petitioner, it is provided that the name of respondent number 6 and 7 be struck off from the array of this petition at the cost and risks and cost of the petitioner. Since service in respect of the other respondents stands completed, recessal is the matter for admission hearing. in usual course.
Lordship, a date may be fixed, Lordship. A date may be fixed, Lordship.
Is of 25
Admitted.
matter
It is not
After-
admitted, Lordship.
after
Permission 27,
Obliged, Lordship.
item 13.
For the opposite party.
Where is the applicant?
Is not here.
After some time, wait for some time.
Let it come after 3 or 4 weeks, because I also need to file an objection, and because of this. Rosa, my lord, this person's concerned person is out of station, so after 25th, any date,
25th of
March, he will be returning on 25th. The concerned person will be swearing the affidavit, my lord.
none appears for the applicant on call. However, Mr. A does learned counsel for the opposite parties present. Mr. Das submits that the matter may be listed after 25th of March as the opposite party will file an objection in this petition. Where allowed recess unless the matter after 25th of March. In the event of subsequent non-representation of the applicant, the appropriate orders will follow.
And declare.
Item number 14.
May I please, Your Honor? Well, this matter relates to transfer of the petition. Okay, the husband has filed a divorce suit at Hailakandi because she was ousted from the house in 2018 with a child. Now, with torture matter, she filed a domestic violence case at Silchar, where her husband is regularly attending. And now she has filed a divorce suit before this again Hailakandi. Prior to this, my lord, a divorce suit was filed. May I please, sir? Matter fixed for consideration of interim order today, my lord. What the
Service is yet to be completed.
my lord, the husband already informed as because on 13 lower court.
No, you say service could not be effected upon him. The report is that no such address, person,
My lord,
RTS.
my lord, I have sub upon responded in the petition, my lord. His petition, my lord. Page number 9, my lord. The respondent is addressed this thing. As per his statement. Already we know about the filing of this. As because on.
No, you say this office note indicates that unserved notice returned to the sole respondent. Returned. And unserved notice issued to the respondent returned with the comment no such address. Struck person RTS.
As per his petition, address was.
Maybe you obtain instruction from the petitioner regarding the address of the respondent and take step accordingly. Heard, Mr. Your name, please?
RK Dutta.
Learned counsel for the petitioner. Office note dated 21/2/2026 indicates that neither unserved notice nor ID card. No, unserved notice. No, notice issued to the respondent returned unserved with a comment no such address struck person RTS. inverted comma. Accordingly, it is provided that the learned counsel for the petitioner shall obtain instruction and take fresh step upon the respondent by speed post and also by usual process within a week from today. Rest shall list the matter after 4 weeks. Interim pair of the petitioner will be considered on next step. You take next step.
Item for application, item number 1 and 2, authorization.
So the matter for the dimension that is like this.
Item number 3 by VC Moore.
May please, my lord. My lord, this is an application under section 2, article 227 of the Constitution of India. Challenging the judgment and decree of learned civil judge Karimganj, my lord, senior division Karimganj. My lord, this decree, my lord, in my humble submission is a nullity. Because my lord, at page 18 of the petition, my lord, may come to page 18 of my petition.
Yes.
At para 20, my lord, the petitioner respectfully submits that the construction of so and so, the Power Grid Corporation of India exercises its power under Chapter 3 of the Indian Telegraph Act 1885. Now, at section 16, my lord, below the page, my lord, section 16, exercise of powers conferred by section 10 and disputes as to the compensation in case of property other than that of a local authority. 16.1 says if the exercise of the powers mentioned in section 10 in respect of the property referred to in clause D of the section is registered or obstructed, the district magistrate in his discretion order that the telegraph authority shall be permitted to exercise them. Now, my lord, the relevant portion is at subsection 3, my lord, of section 16 at page 19. If any dispute arises concerning the sufficiency of compensation to be paid under section 10, clause D, it shall, on application for a purpose by either of the disputing parties to the district judge within whose jurisdiction the property is situated, may be determined by him. Now, the powers by the special act, Indian Telegraph Act, the powers of adjudication for compensation is only vested with the learned district judge, not by the civil judge senior division. Now, the learned civil judge senior division usurped the powers of the learned district judge and took the matter upon itself to adjudicate this matter. My lord, certain decisions, my lord, which I may place, my lord may give me some time because there are no direct adjudicated case laws. There's one of Sansuri Cement versus Power Grid settled by the Supreme Court and another by the Honorable Kerala High Court. These judgments I may be allowed to produce before my lord. In the meantime, my lord may fix this matter on 12th or 17th of March, my lord. Early date may be fixed. So this matter may be done with, my lord.
Okay. Execution proceeding has been stayed. That is the problem. Execution is going on. That is the mistake. That is the problem. The question only the maintainability of the civil division. How against the decree, my lord, the civil division is maintainable. There is a provision. How the civil division is maintainable. First submission. Second is that, my lord, under section 3 of the Telegraph Act, the only district judge is, my lord, he is the authority to determine the compensation. This is their case. Now, section 3 does not say so. It is in respect of sufficiency of the compensation that is to be decided, not the compensation. On this point, small point. How the civil division is maintainable, how section 3 is attracted in this.
My lord,
So the learned trial court has passed the decree.
Right.
And that decree is appealable, according to you, according to you.
According to me. How civil division is made. And there said that section 3 of the Telegraph Act, it is, a district judge is the authority to decide the compensation. District judge is not decide the sufficiency of the compensation. If there is less or more, then it can be decided. For declaration of minor compensation, district judge is the competent authority. And
my,
so for maintainability question, my lord, that issue was raised in titles.
my lord,
That was rejected.
if I may say so, my lord. My learned friend is right only in one aspect. We have got alternative remedy as far as this decree is concerned. Had it not been for the issue of lack of patent inherent jurisdiction, ab initio, the learned civil judge had no jurisdiction to enter enter into the merits of the case. My lord, this is because we have two issues. One second issue, we had to go to the appellate court. That is obtaining this decree by fraud. They had already been paid a compensation. The husband and wife, husband and son of this petitioner, of this respondent, had already been paid a compensation which was hidden from the trial court. But other than that, it is a lack of a patent lack of inherent jurisdiction, my lord. And I'll satisfy my lord with the necessary case law.
No, that's all right. If the decree, whether it is right or wrong, is passed and that decree is appealable, whether this civil revision petition is maintained.
Under 227, my lord, the superintendence of powers of the High Court, I'll satisfy my lord. My lord, when there's a patent lack of inherent jurisdiction standing on the face, this decree is a nullity and void ab initio. Then, my lord, your dishonorable court can interfere. I'll satisfy my lord. My lord may give me until fix a date on a Tuesday or a Thursday, 12th or 17th of March. Matter can be settled, my lord.
Heard, Mr. R. Sharma, learned counsel for the petitioner, learned senior counsel, assisted by Ms.
N. Khera, my lord, he's on
N. Khera, learned counsel for the petitioner, and Mr. N. Hock, learned counsel for the respondent number
1 and 2.
1 and 2. Mr. Gogoi for respondent number
I am for 4, 5, 6, and 7.
4, 5, 6, and 7. And you? Respondent number 3. Respondent number 3. Mr. Sharma, learned counsel for the petitioner submits that the decree, judgment and decree so passed by the learned trial court is void ab initio, as the learned trial court has no jurisdiction to entertain such a entertain the case and to pass a decree, as under section 16
3 months.
16 subsection 3 of the Telegraph Act, the power is vested upon the district judge only. Whereas the impugned judgment and decree was passed by learned civil judge senior division who has no jurisdiction to entertain the said case. And he prays for granting him 2 weeks time to satisfy this court on the point of maintainability of this petition, where allowed receipts are less than a per on
19 March, Thursday.
19th of March. Sorted
On 12 March.
12 of March.
Now, interim orders passed earlier may continue.
Interim order passed earlier shall continue.
Item number 4.
Applies.
May I please, your lordship?
Item 4.
Yes,
In brief, Lordship, what has happened in this case, Lordship, the written statement was filed after beyond the period of 90 days, Lordship. It is not permitted,
written
Lordship.
statement was filed
After the period of 90 days, Lordship.
after 90 days.
90 days. In fact, Lordship, earlier, written statement was rejected, but not taken up by the trial court, and subsequently 7 months, after 7 months, Lordship, a petition was filed under 151 CPC without any exceptional ground, and they have accepted their written statement, Lordship. Written statement of the defendant, Lordship. The plaintiff at the trial court, Lordship.
Where is the impugned order?
Impugned order, Lordship, 43, Lordship, where the written statement was accepted, and another, Lordship, at page 35, where written statement was rejected. At page, Lordship, can you say page 35? Page 35. Plaintiff is represented. Hazira on behalf of defendant number 8 and 9 is filed. Hard learner counsel for the plaintiff regarding acceptance of written
Page
statement.
number?
Page 35, Lordship. Annexure C.
Yes.
Hard learned counsel for the plaintiff regarding acceptance of written statement filed by defendant number 8 and 9. Peruse the case record. It appears the defendant 8 and 9 had submitted the written statement after expiry of statutory period of 90 days. Hence, written statement filed by defendant number 8 and 9 is hereby rejected, and the suit shall proceed to the next stage. And thereafter, Lordship, after 7 months, Lordship, at page, Lordship, 43, page 43, Lordship. Page 43. May I read, Lordship? The plaintiff is absent without any steps. In fact, Lordship, we are present, Lordship. We have filed a Hazira, Lordship. The defendant number 8 and 9 are represented by their engaged counsels. Today is the date fixed for necessary order on petition number so and so. Seen petition number so and so filed by the defendant, petitioner defendant Abdul Motin under section 151 of the Code of Civil Procedure, when it is submitted that on 2/5/23, the instant suit was fixed for written statement of defendant number 8 and 9, but due to lack of certain certified copies of defendant number 8 and 9, could not submitted the same on 2/5/23, and that the suit was fixed on 26/6/23 for submission of written statement. It is further stated that the defendant petitioner submitted a written statement on 26/6/23, and that the next day should have been for issue document. It is further stated that later on the petitioner came to know while order is at 31/24, the written statement filed by the defendant number 8 and 9 was rejected, which the defendant was accordingly prayed for accepting the written statement filed by them and to fix the instant case for issue document. The counsel for the defendant petition defendant has placed reliance on the following judgment passed by the Honorable Gauhati High Court, Usman Ghani versus and others versus Abdul Khalek and others, 2008 3 GLT 179. The plaintiff, Mohammad Sanmia, on the other hand, has filed written objection against the petition under section 151 CPC, wherein it is stated that the petition is not maintainable, that there is no cause of action for filing the instant petition and is also barred by law of limitation. It is further stated by the plaintiff, the written statement filed by defendant number 8 and 9 was rejected as they have submitted the written statement after expiry of statutory period of 90 days. It is also stated by the plaintiff, the defendant number 8 and 9 raised the objection against the order dated 31/24 on 28/8/24 after 7 months from the passing the said order, and as of the petition filed by defendant is liable to be dismissed. Heard and peruse the case record. On perusal of the case record, it is seen that this court on 26/6/23 fixed the instant case for submission witness statement. It is also seen from the perusal of the record that 26/6/23, the defendant number 8 and 9 submitted a witness statement, and no order of rejecting the witness statement was passed on that day. The Honorable Gauhati High Court, Usman Ghani and others versus Abdul Khalek and others, 2008 3 GLT 179, in a similarly situated case had allowed the defendant to file a written statement. Considered as such, the petition number so and so filed by the petition defendant number 8 and 9 is allowed, and the written statement filed by them is also accepted. Fixed 21/3/25 for ADR issues documents, and the written statement is accepted. Lordship. In fact, Lordship, so far law is concerned, Lordship, they have filed a 151 CPC petition under 151 CPC after 7 months of rejection of the written statement. In between 6 days are elapsed, Lordship. But they have, after 7 months, they are coming, and Lordship, no exceptional ground has been shown in the 150, that petition under 151 CPC, and I have annexed that petition also, Lordship, where they have filed. At page, Lordship, 36. Page 36, Lordship. No exceptional ground has been shown, Lordship. Page 36.
Yes, what is your submission?
Little. If, your lordship, will just page number 31.
51,
31.
31.
The type copy of order dated 3/4/2023. 30.
Yes.
Please remaining casually, plaintiff is represented. Summons issued to the defendants number 3 to 9 have been duly served on 28/3/2023, lordship. 28/3/2023, lordship. And 90 days is to expire on 28/6/2023, lordship.
90 days is to be expired on
28/6/2023, lordship.
yes.
We have filed our WS lawsuit on 26/6/2023, lordship. That is well within 90 days, lordship. But due to some inadvertence, lordship, this WS was rejected. Before we have filed our WS before this, lordship, before the expiry of 90 days, lordship. And due to some inadvertence, lordship, that
Where is your WS? Page
I
number?
have not annexed the written statement.
W
I have not annexed the written statement.
Okay.
and about the fact that, lordship, we have filed the section 151.
No. How do you justify that you have filed a written statement on 26/6/2023?
It is reflected in the order.
Which order?
— 26/6/2020.
Page number 33?
33, lordship. PO is availing earned leave, increase represented dependent number 46, 8 and 9 are also represented, dependent number 8 and 9 submitted their written statement. Third or fourth line, lordship. Order dated 26/6/2023. PO is availing earned leave. Plaintiff is represented. Defendant number 8 and 9 are also represented. Defendants number 8 and 9 have submitted their written statement. But you have filed a written statement on that date, 26/6/2023. That is well within 90 days, lordship.
So the observation made in the order dated 38/1/2024 is incorrect.
Lordship.
Yes, Mr. Sharma?
And on that date, lordship, on 26/6/2020, there was no order of rejection of the WS, lordship.
The PO is not there, Lordship. On that day, PO is availing leave. So that day, written statement,
But order
no order was passed.
Order was passed. 26/6/2023, Lordship, order was passed.
So the written statement appears to be filed within the period of 90 days. You see page number 33. And also see the page number 31, where it is recorded that the notice was served upon them on 28/3/2023. So the period of 90 days has to be counted from 28/3/2023. So if it is the factual position, then the written statement was filed within the period of 90 days. So there is no wrong in the order.
So far, the Lordship, they have filed a petition in the 151 CPC for accepting the 18 statements. But something is wrong, Lordship, because they have not filed.
There was a.
They ought not to have filed a.
The fifth, because he was on leave on that day. There is a judgment of the apex court, Lordship, whereby the court, Lordship, if I may read, Lordship. Once the court comes to the conclusion that the wrong order has been passed, it becomes the solemn duty of the court to rectify the mistake rather than perpetuate the same.
You furnish it to the court master.
No, I want to place.
Okay.
The-
We are dismissing the petition. You go and fetch the tray.
I want to place some judgment, Lordship, regarding.
Number 26, order me.
Obliged.
May I please the Lordship, my Lord. My Lord, as per the order dated 16/12/2025, my Lord.
Affidavit file. Affidavit file.
Education, secondary. Limited. My Lord, this was a part hard matter, my Lord. The only issue, my Lord, remains in here in this case, my Lord. On last occasion, my Lord, I was
That's okay,
direct-
but the respondent.
I am for the petitioner, my Lord. I was directed to produce the, my Lord, student attendance register, my Lord, right from the year 2009 till 2017, my Lord. Because there was an inspection report which comes in my favor, my Lord. And Lordship was pleased to, my Lord, just verify this inspection report and to compare this inspection report along with the teacher's attendance register, my Lord. I have, my Lord, annexed.
After some time, let the council come.
It's a part of record. In fact, I have brought the, my Lord, the original records also.
That's all
Student-
right. Let the other side come.
My Lord.
Go be informed.
Coming again, 1 and 2.
The two messages get okay.
Yes.
That has already made their submission.
Yes, yes.
My turn to my response. So basically, two cases. In one case, they have challenged one of the joint scrutiny committee, resolution number 6, by which the joint election scrutiny committee has got some clarification from the authorities, because in the minutes, the date is not mentioned. That is in one case. That is in Arshad Ali Sheikh's case, 6870. Here, the challenge is only the resolution of the joint scrutiny committee. In the other case, Utpal Nath, they have challenged the very constitution and existence of the joint scrutiny committee. So according to them, they have very categorically stated that this committee is not a statutory body, and therefore they cannot function. And therefore they have challenged the whole constitution, because in their meeting, it was found that there is some discrepancy about the number of enrollment in the schools. If Lordship is pleased to come, page 28 in WPC 6997, Polnath. page 28. Yes, fourth line from top on the right hand side, however. However, government placed the matter before the impugned joint committee, which is not a statutory body, and the joint committee directed verification and re-verification of the recommendations from this and this authority by sitting as an appellate authority over the statutory body like DSC and SLSC. So there are two committees who are empowered to do the scrutiny regarding any proposal or any request for regularization under the 2017 Act. And that provision you will find in section 13 of the Assam Education Provincialization of Services of Teachers and Reorganization of Educational Institutions Act 2017. So I will say Act 2017. So this Provincialization Act of Act 2017 in section 13 says District Scrutiny Committee and State Level Scrutiny Committee. There are two committees which has been envisaged in this act. First, the district committee, may I just read the relevant provisions? 13 subsection 1 says, there shall be a district scrutiny committee in each district separately for elementary, secondary, and for higher education to scrutinize service records and other related issues of the serving teachers of venture educational institutions pertaining to provincialization of their services. Now, subsection 2, the deputy commissioner of the district by an order shall constitute the district scrutiny committee for the respective districts under the preceding subsection. So the committee is constituted as per the persons which are mentioned in subsection 3. Now, Lordship will come to 4 and 5, the secondary as well as the district committee for the elementary schools. Now, Lordship will kindly come to subsection 6. The district scrutiny committee shall first scrutinize and prepare a list of all venture educational institutions within the district which are eligible in terms of the provisions of this act, and shall thereafter proceed to scrutinize and verify the service records of all the serving teachers who are eligible or who become eligible for being considered for provincialization of their services. The district committee shall identify a base school for each category of schools and recommend the name or teachers or tutors to be associated against each base school. So Lordship will kindly mark the word recommend in subsection 6. So the district committee, after doing the scrutiny and after examining all the records, will recommend the name of the teacher or the tutor or the school for provincialization. They will recommend to whom? They will recommend it to the state level committee. Subsection 7 now. The district scrutiny committee shall forward the verified list of eligible teachers based school-wise in accordance with the act to the concerned director, who shall place the matter before the state level scrutiny committee to be constituted under subsection 10 of this section, and after making such further scrutiny as may be required, shall forward the same to the concerned department of the state government for consideration and for issuing notification in respect of the eligible institutions and teachers eligible for getting their services provincialized. So after the district committee done this exercise and recommends the name, the director of the secondary or elementary school will place it before the state level scrutiny committee, and the state level scrutiny committee will further scrutinize the proposal, and thereafter, once they are convinced, they will send the proposal to the state government for consideration. Lordship will have to mark this for consideration. And for issuing notification in respect of the eligible institutions and teachers eligible for getting their services provincialized. Now coming to section 4 of this act. How the state government will proceed, that is there in section 4. Section 4, Lordship will find page. Yes, page 114. Teachers and or tutors to be government servants.
subject to fulfillment of all other provisions of this act, the services of the teachers or tutors of all venture education institutions eligible under section 3 shall be deemed to be provincialized on the date of publication of the provincialization order by notification in the official gazette, and they shall become employees of the state government with effect from such date. So the government is duty bound to issue a notification those who are found to be eligible for provincialization. Now, here the issue is like this. The district level committee will do the exercise and recommend the name to the state level committee. State level committee redo the work again of scrutinizing the proposal. And once they are satisfied, they will recommend to the concerned department. That is, it may be elementary education department, it may be secondary education department or higher education department. The three components of the government for their consideration, and once satisfied, the government can issue the provincialization order so that they become government employees. So this is the sequence of events. So now, according to that, once the state district level committee recommends it to the state level committee and the state level committee sends a proposal for government for consideration, what they are proposing is that the government has no other business but to issue the notification under section 4. My submission will be that there is another exercise which is contemplated under subsection 7 of section 30 that government will have to consider. Whatever the state level committee is not automatically binding upon the government to issue the notification. The law as propounded by this under this act very categorically use the word consideration. If Lordship is pleased to come to section 7 again says the state level committee shall forward the same to the concerned department of the state government. That means to the state government for consideration and for issuing notification. So there are two words. One is consideration, and once it is considered, and it's a conjunction for issuing notification in respect of the eligible institutions and teachers eligible for getting their services provided. So the government will have to consider, and if the government finds that the particular student, teacher or the particular institution are fit for regularization or provincialization, that notification will be issued. So we have to take the meaning of consideration here. What exactly is the meaning of consideration? Because a particular duty is entrusted to the government before issuing the notification. And the scheme of things as per this Act of 2007 very clearly says two exercise and two events are taking place before the district level committee and the state level committee. But that is not sufficient for issuing the notification under section 4. In between, there is another exercise to be done by the government to be satisfied that whatever recommendation or proposal is coming from the state level committee, automatically it is not mandatory for the government to issue the notification. In this respect, I would like to place the meaning of the word of the Supreme Court as enunciated in the case of barium chemicals versus A.S. Rana, 1972, 1 SCC, page 240. The meaning of the word consider. 1972, volume 1 SCC, page 240. Paragraph 14, may I read it, Lordship? The word consider it necessary postulate that the authority concerned has thought over the matter deliberately and with care, and it has been found necessary as a result of such thinking to pass the order. The dictionary meaning of the word consider within inverted comma, within this quoting, consider is to view attentively or survey, examine, inspect, to look attentively, to contemplate mentally, to think over, meditate on, give heed to, take note of, to think deliberately, rethink oneself to reflect. That is by Oxford Dictionary. According to words and phrases, permanent condition, to consider means to think with care. It also mentioned to consider is to fix the mind upon with a view to careful examination, to ponder, to study, to meditate upon, to think or reflect with care. It is therefore manifest that careful thinking or due application of mind in the necessity to obtain and examine the documents in question is sine qua non, that is an essential condition for making of the order. If the impugn order were to show that there has been no careful thinking or proper application of mind as to the necessity of obtaining and examining the documents specified in the order, the essential requisite to the making of the order to be held to be non-existent. So the government, when the proposal has come to it for consideration, it cannot mechanically pass the order of provincialization under section 4. To consider, the government has to apply its mind, verify the documents, verify the facts, and only if it is satisfied, then only they will proceed to section 4 for issuance of the notification for provincializing the service of the particular teacher or to provincialize the particular institution. So this is the meaning of consideration, and it has been given by 5 judges bench. If Lordship is pleased to come to the first page. 5 judges constitution bench. Justice Sikri, Justice Sela, Justice Dua, Justice Khanna, and Justice Mitter. So 5 judges Supreme Court Constitution bench has formulated the meaning of considered. Now coming to paragraph 15 of the same judgment. A necessary corollary of what has been observed above is that mind has to be applied to regard to the necessity to obtain and examine all the documents mentioned in the order. An application of mind with regard to the necessity to obtain and examine only a few of the many documents mentioned in the order, while there has been no such application of mind in respect of the remaining documents, would not be sufficient compliance of the requirement of the statute. If, however, there has been consideration of the matter regarding the necessity to obtain and examine all the documents and an order is passed thereafter, the court would stay its hand away in the matter and would not substitute its own opinion for that of the authority concerned regarding necessity to obtain the documents in question. So the plain meaning of this is that when a proposal is come for consideration, the appropriate authority has to verify and examine all the documents, all the materials placed before it in the proposal. If it is not done, then the final outcome may not be correct. In that case, the court may have to interfere. In our case, the Joint Scrutiny Committee has verified and found that there is discrepancy in the minutes, which propose the provincialization of the particular teacher. And in the other case, regarding 2 facts came before it. One says that there are X number of students in that school. The other says Y number of students enrolled in that school. So 2 different facts have come. Therefore, the Joint Scrutiny Committee has sent back the proposal for further verification by them and coming to a further conclusion. So government has applied this mind. It is not that automatically. Till now we have Till now we have done about 5,000 teachers provincialization and more than 40,000 tutors. Tutors are not fully qualified, so they are given a lower post. If they acquire the same qualification, they will also be given the position of teachers. So 45,000 persons were verified and this scrutiny committee has cleared them. In case of few odd ones where the verification has to be done because there are flaws in the proposal. Now, whether that is a statutory body or not, it is not required to be a statutory body. 2 statutory bodies are already there, the district level committee and the state level committee. But what will be the role of government? How the government will consider the proposal? That in that respect, the Education Act of 2017 is totally silent. In that situation, the government has exercise the mandate of Article 162 and issued the two notifications which Lordship will find in our affidavit in Utpalnath case. We have annexed both the notifications. This is put to challenge. 27 January 2019, the Government of Assam Finance SIU Department. The Governor of Assam is pleased to constitute the committee as mentioned below to examine the cases of provincialization, the services of teaching staff of educational institutions under the provisions of 2017 Act as amended. Chairman Seba, then the becomes again the Commissioner of Education Department, GK Pegu, Additional Secretary Finance Department, and Director Secondary Education, Assam. This was the first notification regarding constitution of the Joint Scrutiny Committee and the terms and reference of the committee to examine the proposal. Why it is examined? Because under the Act, government has to consider, and consider means examination of the proposal. The Supreme Court just now I have placed that judgment. To examine the proposal received for provincialization of secondary schools and teaching staff thereof, and to ascertain whether proposals are in accordance with the relevant provisions of Assam Educational Provincial Act 2017 as amended, to obtain further information, clarification required, if any, from competent authority person, applicant, educational institution, to obtain certification from the appropriate authority of all information provided for provincialization of schools and teaching staff, secretarial assistance by the Education Department. And the committee shall submit its report within 7 days from the date of notification. So the government deemed it appropriate that if a committee which consists of the personnel from Education and Finance Department, that will expedite the process of provincial. Therefore, 7 days time was given. And it was further amended in the next page, Lordship will find 27 February 2019. Sorry, it is 14 September 2022. There's just some change of the representative of the Finance Department. Pradeep Sharma, Deputy Secretary, he entered into the committee. And the Director of Elementary and Secondary both, because we are also examining both elementary and secondary. So the terms of reference are also same. There is a slight modification of the committee. One more judgment regarding consideration, Lordship will kindly take note of. 1976.
No, you please tell me one thing, whether it is a notification dated 27th of January 2019 is superseded by the subsequent notification?
There is a slight amendment, yes.
Okay.
The person's name will change. If I am not, let me examine. 22nd, 14 September 2022. Initially, yes, partial modification. So may I read it?
Yes.
Pursuance of the administrative so and so, notification dated so and so, and in partial modification of the notification of 5/8/22, the Governor of Assam is pleased to reconstitute the Joint Committee for Provincialization Service. So this is a reconstitution of the committee. If the first is bad, this is also bad. If the first is valid, then this is also valid. So there is no discrimination. In the second one, elementary education has been inducted. If Lordship is pleased to see serial number 4, Director Secondary Education.
Yes,
the first. In the second, both Director Elementary and Director Secondary were inducted, and GK Pegu was there in the first from the Finance Department. Now Pradeep Sharma has entered into the committee. Yes, and Vikram Saitya also in the meantime superannuated. So in his case, in his place, senior most secretary, Department of School Education, and those departments were also amalgamated. But terms of reference in my humble submission is more or less same.
But in none of the notification, it has been mentioned that the governor has exercised the power under Article 162.
Article 162 that may not be there because all the administrative orders comes under Article 162. All, whatever order the government pass in its administrative capacity, they automatically come under Article 162. Let us read Article 162. Extent of Article 162. Extent of executive power of the state. All exercise done by the state government will be under this. Whatever other things also, it will come under the source is 162. The effect of this article read, subject to the provisions of this constitution, the executive power of the state shall extend to the matters with respect to which the legislature of the state has power to make laws. So the state government has, through the legislature, enacted the 2017 Provincialization Act. So subject to provisions of this, the executive power of the state shall extend to the matter with respect to which the legislature of the state has power to make laws, provided that in any matter with respect to which the legislature of the state or parliament has power to make laws, the executive power of the state shall be subject to and limited by the executive power expressly conferred by this constitution or by any law made by parliament upon the union or authorities thereof. So the state government has already enacted the Provincialization Act of 2017, under which two statutory body has been contemplated. One is the district level scrutiny committee, the other one is the state level committee. And the state level committee, after getting the proposal from the district level committee, the state level committee have to recommend the provincialization to the government for consideration. And consideration, I have said that government have to examine. The ipso facto, the government, the district level committee's recommendation, it is not binding upon the state government to accept. It has to apply its mind, and if the proposal is in order, then notification will be issued. Otherwise, clarification and modification and re-verification can be done. And Article 166 also, Lordship will kindly see.
Yes.
Conduct of business of the government of the state. All executive action of the government of a state shall be expressed to be taken in the name of the governor. Order and other orders made and executed in the name of government shall be authenticated in such manner as may be specified in rules to be made by the governor, and validity of an order or instrument which is to authenticated shall not be called in question on the ground that it has not been an order or instrument made or executed by the governor. The governor shall make rules for the more convenient transaction of the business of the government and for allocation among ministers, the said business insofar as it is not business with respect to which the governor is by or under the constitution required to act in his discretion. So we are covered by 166(1), 166(2), and 166(3) partially. All the notifications issued by the government, all the notifications, circulars, orders, if it is issued in the name of governor, it is under 166 and 162. Even if it is not issued under the name of governor, then also it is under 162 and 166. It may be mentioned, it may not be mentioned, but whatever exercise the state government done in its administrative capacity will automatically come under the mandate of Article 162. In this case also, if proceedings, please to look at the two orders. Page 115 once more. Here there is no mention of 162 or anything. Here it is said, the governor of Assam is pleased to constitute a committee as mentioned below to examine the cases of for provincialization. So the governor, on behalf of the state of Assam, has issued this notification to constitute the joint scrutiny committee. And impliedly, it is under the provisions of 162, that is executive business of the state. So one more judgment before I go to the next part. 1976 PSCC, page 190, Divisional Personnel Officer versus Southern Railway, of Southern Railway versus Tier Chelagam, paragraph 21. 1976, volume 3 SCC, page 190, paragraph 21. Yes. Just 1 second. Go back to the- Here, if paragraph 21, what it will come about 10 lines from top, the word consider on the right hand side. The word consider has been used in contradistinction to the word determine. The rulemaking authority deliberately used the word consider and not determine because the word determine has a much wider scope. The word consider merely connotes that there should be an active application of the mind by the disciplinary authority after considering the entire circumstances of the case in order to decide the nature and extent of the penalty to be imposed on the delinquent employee on his conviction on a criminal charge. This matter has been objectively determined only if the delinquent of his employee is heard and given a chance to satisfy the authority regarding the final order that may be passed by the authority. In other words, the term consider postulates consideration of all the aspects, the pros and cons of the matters after hearing the aggrieved party. So here, the aggrieved party hearing is not the issue. The issue is whether the role of the government while considering a proposal. While considering the proposal for consideration, the government will have to apply its minds on all aspects, pros and cons of the matter. And the earlier case, it was much wider. The Supreme Court in the Constitution Bench judgment in barium chemicals in paragraph 14 and 15 very clearly says what is the literal meaning, what is the dictionary meaning, and what are the things that has to be considered while giving a meaning to the word consideration. Consider. So now we have to see. We have to see whether this act is complete if we consider section 4 and section 30. In my humble submission, how the district authority, district level scrutiny committee, state level committee will do its and transact its business, it has been given within the act and the rules framed thereunder. In the rules also very clearly says how the proposal has to be examined, how the applications are to be made, what are the parameters to be looked into. Everything is given in detail. But when the recommendation of the proposal is sent to the government or placed before the government in the appropriate department by the state level committee, how the government will consider the proposal, the act is totally silent. Only the word considered by the government is there. If Lordship is once more pleased to come to that particular line. 13.7. The state level committees are under the Spencer, and after making such further scrutiny, that means the district level proposal has been further scrutinized by the state level committee as may be required, shall forward the same to for the concerned department of the state government for consideration and issuing notification. So there are two events which has been contemplated here. One is consideration, the next event is issuance of the notification. And in between there is a word and. Had there been or, the things would have been a different meaning. But when it is said and, that means first consider, then issue notification. So while considering, we have to go by the meaning of the word consider. That means examination, application of mind, verify the facts, verify the proposal, and if everything is in order, issue the notification. And the second event will come for the government. But the first role the government will have to play is to consider, that is to examine the proposal. How it has to be considered, I could not find anything in the whole act. How the district committee will examine, detail has been given. How the state level committee will do, that has been given. But how the state government will consider the recommendation of the state level committee, the act is silent. In that part, without disturbing any statutory provisions of this act, the government can supplement. And what is that supplementary action taken by the government? Issuance of the two notification in 2019 and 2022 regarding constitution of the joint scrutiny committee, by which the proposal will be examined and government will take the final decision whether to issue the notification or get clarifications from the concerned or competent authorities, that is the district level committee or the state level committee. So the field is occupied in respect of the district level committee and state level committee. But the field is not occupied under this act and the rules framed thereunder regarding the process, regarding the procedure, how the government will consider a proposal which has been placed before it. So that is not there. So in that silent area, in the gray area, where there is a vacuum, this act have to be either amended or in the interim, government can issue a notification by various instruments under the provisions and mandate of Article 162 to fulfill this lacuna. Or government can also amend this act, and how the government will consider by amending this act. Two options were opened before the government. Two paths were there. Government adopted the path of Article 162 instead of going and exercise its power under Article 309. If Lordship is pleased to look at the beginning of this act. So this is a legislative action. So this is not a 309. So government has a proper act here. There are rules also, rules are framed under 309, but here it is the act. So it is a full-fledged legislative action undertaken by the government. The assembly had debated on this act and it was finally approved by the assembly, and therefore the government has received the assent of the governor also. Had it been a 309, all these things were not required. But here it is that the full exercise was done to frame this legislation. So it is a full-fledged legislative action. So when we go to Article 162, once more I will place, the government has the power to amend the act or frame a new law also. In which areas government can issue the administrative orders to fulfill this vacuum, where the government has the power to make laws. So if I please, if Lordship allows me, I will place 162 once more. Extent of executive power of state. Subject to the provisions of this constitution, the executive power of a state shall extend to the matters with respect to which the legislature of the state has power to make laws. So the government has power to make laws regarding how to consider the proposal received from state level committee. Government can enact a law also, but government did not go because that is a lengthy process. Provided that in any matter in respect to which the legislature of a state and the parliament have power to make laws, the executive power of the state shall be subject to and limited by the executive power expressly conferred by this constitution or by any law made by parliament upon the union or authorities thereof. Here, what the mandate says is that the government cannot issue an administrative order to overrule anything, how the district level committee will function, how the state level committee will function. In those areas, the government cannot do anything by exercising its power under 162 to amend anything there. Those areas are already covered by the legislature. Anything has to be done by the government, then lordship, there should be a proper amendment in the assembly. On the other hand, state government cannot pass any notification to override any provisions of the law framed by the central government also. In this case, the state government has power to make law regarding provincialization of schools and colleges in Assam. They have made it. One area which was not covered under Act, in that area, the doctrine of occupied field will come. I'll place that proposition little later once lordship comes to resumes. Okay. In that area, government can interfere. I'd like to place this Assam rules of executive. Lordship will kindly come to the first part of this Assam rules of executive business 1968. It was issued on 5th March 1969 from Shillong. 208. If we are having the same. Yes. Notification. In supersession of the Assam Rules of Executive Business issued under notification dated 6 October 1951 and in exercise of the power conferred by Clause 2 and Clause 3 of Article 166. I have placed just now Article 166 and 162 of the Constitution of India. The Governor of Assam is pleased to make the following rule. So 162, 162, 166 all comes under the executive power of the state in the Constitution, chapter 2. Constitution says chapter 2 is the executive, the governor. So one from 153 onwards up to 156. Everything comes under the executive of the state. So these rules were framed under Article 166, 2 and 3. Here Rule 8. Rule 10, Lordship. Rule 10. Sub-rule 1. No department, that means including education department, no department shall, without previous consultation with the finance department, authorize any order other than orders issued under any act or rules made thereunder or pursuant to any general or specific delegation made by the finance department, which either immediately or by repercussions will affect the finances of the state, or which in particular, Roman 1, involve any grant of land or assessment of revenue or concession grant, lease or license of mineral forest, etc. We are not concerned about that. We are not concerned. Roman 2, in any way involve relinquishment of revenue. B, relate to the number or grading of cadre of post or of emoluments or other conditions of service of post. C, involve the addition of a post in public service or variation of emoluments of any post. D, involve the sanction of an allowance or special or personal pay for any post or class of post or to any employee of the government of Assam. And E, involve an expenditure for which no provision has been made in the Appropriation Act or which is in excess of the provisions made under this Act. So here, provincialization means creation of posts, giving pay scale, emoluments, etc., and which involves revenue of the state. So finance department consultation is mandatory under the Assam Rules of Executive Business, which comes under Article 166, 2 and 3. So here, if we look, if Lordship is pleased to look at the composition of the Joint Screening Committee, 3 persons are from the Education Department and 1 person is from the Finance Department. This is precisely in compliance of Rule 10 of the Assam Rules of Executive Business. Now coming to 11 and 12. All orders or instruments made or executed by or on behalf of the government of Assam shall be expressed to be made or executed in the name of the governor of Assam. So we have done that in the governor's name, 11. And 12 says, Rule 12, every order or instrument of the government of the state shall be expressed to be made in the name of the governor and shall be signed either by the secretary, additional secretary, a special secretary, joint secretary, deputy secretary, under secretary, or such other officer as may be specially empowered in that behalf, and such signature shall be deemed to be proper authentication of such order or instrument. So if we look at this notification at page 115. So at the very beginning, the governor of Assam is pleased to constitute a committee. So Article 166 vis-a-vis 162, and it has been signed by the principal secretary to the government of Assam Finance Department. So first was issued by the principal secretary, and the second one amendment issued by the secretary of the government of Assam Education, where secondary and elementary both were inducted. So through proper authority, through competent persons under the Act and the statute, this has been done. So their case that this is not a statutory body, in my humble submission, it is a statutory body under the Assam Rules of Executive Business, read with Article 162 and 166. So now coming to the doctrine of occupied field. In which situation the government can interfere in any field where there is already a act is in place. Their argument is that this 2017 Provincialization Act has two statutory bodies, the district level scrutiny committee and the state level scrutiny committee. And in that scheme of things under the Act of 2017, there is no scope of having a third committee, that is a joint scrutiny committee. This is their argument. So the government cannot have another committee under the scheme of things for provincialization. And my submission is that I do agree there are two committees which has the power to recommend and not to appoint. The district level committee has the power to verify and scrutiny. The state level committee has the power to re-verify, further scrutiny. These are the words used in the statute itself. So further scrutiny is done by the state level committee, and end of their exercise of scrutiny and examination, they have the role, they have the duty to recommend the proposal to the state government for consideration. For consideration, there is no committee. There is no committee under the Act. So in that area, the government can step in. And that is permissible. We apply the doctrine of occupied field because in district level scrutiny committee, state level, these are the areas where the Act is occupied. So far as the state level, at the state level, no committee has been there, or no committee has been provided under the statute. So in that area, the government can exercise its power under Article 162, read with 166, read with the Assam Rules of Executive Business, Section 10 and Section 11, 12. So to fortify my argument, I'd like to place three judgments. One is 1998 3 SCC page 495. A.B. Krishna versus State of Karnataka. In 1998, volume 3 SCC page 495. Paragraph 8. Lordship may read also 6, 7 and 8. I may read 6, 7 and 8. It is primarily the legislature, namely the parliament or the state legislature assembly in whom power to make laws regulating the recruitment and condition of service of persons appointed to public services and posts in connection with the affairs of the union or the state is vested. The legislative field indicated in this article is the same as indicated in entry 71 of list 1 of the 7th schedule or entry 41 or list 2 of that schedule. The proviso, however, gives power to the president or the governor to make service rules, but this is only a transitional provision as the power under the proviso can be exercised only so long as the legislature does not make any act thereby recruitment to public post as also other conditions of service relating to that post are laid down. The rulemaking function under the proviso to Article 309 is a legislative function. Under Article 309, since Article 309 has to operate subject to other provisions of the Constitution, it is obvious that whether it is an act made by the Parliament or the state legislature, which lays down the conditions of service, or it is a rule made by the President or the Governor under the proviso to that article, it has to be in conformity with the other provisions of the Constitution, especially Article 14, 16, 310 and 311. The fire service under the state governments were created and established under the Fire Force Act 1964, made by the state legislature. It was in exercise of the power conferred under Section 39 of the Act that the state government made the service rules relating to the conditions of fire services. Since the fire services had been specially established under an act of the legislature, and the government, in pursuance of the power conferred under that act, has already made service rules, any amendment in the Karnataka Civil Services General Recruitment Rules 1977 would not affect the special provisions validly made under the fire services. As a matter of fact, under the scheme of Article 309 of the Constitution, once a legislature intervenes to enact a law regulating the conditions of service, the power of the executive, including the president or the governor, as the case may be, is totally displaced on the principle of doctrine of occupied field. So where the act is made, the government cannot interfere. Only exception is if, however, any matter is not touched by that enactment, it will be competent for the executive to either issue executive instructions or to make a rule under Article 309 in respect of that matter. So this is very important, that exception. Act may be already framed by the state legislature, but if there is some area which is not covered by that particular legislation, in that area, the government, in any matter which is not touched by that enactment. So in our case, consideration by the government, how it has to be done, who will do it, there is no indication. So that area is silent, that area is gray area. So any matter is not touched by that enactment, that is Act of 2017. It will be competent for the executive, that is for the state government, to either issue executive instructions or to make rule under Article 309 in respect of that matter. So this is precisely what we have done. Now coming to paragraph 9. It is no doubt true that rulemaking authority under 309 of the Constitution and Section 39 of the Act is the same, namely the government, to be precise, the governor under Article 309 and the government under Section 39, but the true jurisdictions are different. As has been seen above, power under Article 309 cannot be exercised by the governor if the legislature has already made a law and the field is occupied. In that situation, rule can be made under the law so made by the legislature and not under 309. It has to be noticed that rules made in exercise of the rulemaking power given under an act constitute delegated or subordinate legislation, but the rules under 309 cannot be treated to fall in the category, and therefore, on the principles of occupied seat, the rule under 309 cannot supersede the rules made by the legislature. So what we are doing by issuing that notification, an instrument by the state executive to constitute the joint scrutiny committee, we are not overriding or we are not conflicting with any provisions of the act. We are not usurping the power of the district committee or the state level committee. Whatever has been to be done by the state level, the joint committee is in the domain of the government. Because the act itself has transferred the responsibility to the government after the exercise has been conducted by the district level committee and the state level committee. The recommendation is made for the government to consider. From that point onwards, the government is basically examining the proposal which it has received before issuing the final notification to make them government servant. So we are covered by the principle of occupied doctrine of occupied field because we are not touching the field already occupied in the act. What we are touching is the field which is not occupied, which is silent, which is gray, and which is not provided in the act. In that situation, we are not acting in any manner which can be termed as arbitrary or repugnant. So this joint committee is not repugnant or it is not in conflict with the role to be played by the district level committee or by the state level committee. We are just supplementing the role of the government by exercising its authority to verify, and if anything is found not in order, it will remand back the proposal to the district level or the state level committee for further clarification, further verification, and also further certification if required. One more judgment on this point, 2006, 9 SCC, page 69, paragraph 19, Satyanarayan Shukla versus Union of India. Paragraph 19.
Yes.
The appellant contended that this provision of the central staffing scheme is ultra vires Article 309 and 3012 of the Constitution. Amplifying this, it is urged by the appellant that several rules has been framed by the central government in exercise of its statutory power under AIS Act 1951, that is Indian Administrative Service Cadre Rules 1951, and Indian Administrative Service Fixation of Cadre Strength Regulation 1955. Indian Administrative Service Pay Rules 1954, Indian Administrative Service Regulation of Seniority Rules 1987, Indian Administrative Service Probation Rules 1954. And these rules occupy the whole field of executive discretions, and therefore, by the doctrine of occupied field, there is no scope left for exercise of executive action outside the purview of these rules. So same argument was made there. It is difficult to accept this contention. Each one of these rules is intended to take care of a specific facet of IAS. No set of these rules is exhaustive by itself of all the service conditions applicable to the Indian Administrative Service. It is therefore incorrect to contend that the field of possible executive action is completely occupied by the statute or the statutory rules framed thereunder, deriving force from Article 309 read with Article 312 of the Constitution. We have not been shown any provision by these rules which deals specifically with the subject of procedure of selection of officers from the said cadre for the post of additional secretary to the government of India. This is a subject in respect of which the field does not appear to be occupied. Consequently, it was very much open for the executive to resort to executive instructions by way of an office memorandum for dealing with this subject. The contention therefore must fail. The same argument was made that it is an occupied field, already there are two committees. Here, one particular area, how the additional secretary or the additional secretary to the government of India, their promotion and their procedure for selection is not there in all these 5 or 6 rules from 1955, 54, 51. So one area was not covered by those rules. In that area, the state executive can interfere. And that is precisely what is said. This is a subject in respect of which the field does not appear to be occupied. So it is not an occupied field. In my case also, consideration by the government, the procedure is not occupied under that Act of 2017. Consequently, it was very much open for the executive to resort to executive instruction. That is under Article 162, or if it is central government, there is another provision. I think 94 or 74, the central government. Same parametric provisions. It was very much open to the executive to resort to executive instructions by way of an office memo, which we have issued in 2019 and 22 for dealing with this subject. So one particular area, this can be done. The contention therefore must fail. And these principles were followed by this honorable court in Gauhati High Court, which is reported in 2017 6 SCC, 2017 6 GLR, page 381, Mohendranath Mudoi and others versus State of Assam. This was a long drawn litigation, Lordship. It started sometime in 2011-12. There was a challenge to the 2003 education service rules of secondary education. The contention was that 2003 rules is repugnant to 1981 state governments. There is another education rules. The division bench initially set aside the 2003 rules because 2003 rules occupied the field already governed by 1981 rules of the state government. We filed a review application, and in the review application, the initial judgment of the writ petition was set aside, by which the rule was found to be ultra virus and violations. Thereafter, a fresh hearing took place, and after the review, the matter was once more remanded back to a different division bench because the judgment was delivered by my Lord Justice Anima Hazarika and my Lord Justice Amitabh Roy initially. That judgment was reviewed by my Lord Justice Supreme Chief Justice and my Lord Justice Anima Hazarika, which set aside the third judgment of the writ proceedings. Thereafter, the fresh hearing had taken place before my Lord Justice Ujjal Bhuya and my Lord Justice K.R. Surana, and judgment was delivered on 31/7/2017. The basic ground of the original challenge was that 2003 rules cannot be framed by the state because the field was already occupied by 1981 rules. Here, I would like to place only two paragraphs, paragraph 54 and 56. And ultimately, 2003 rule was upheld because it was not covering, or it was not interfering, or it was not in repugnant to the rules of 1981. 54 and 56. I am on the law, not on the facts here in this case. But this is the outcome. This was a litigation continued for about 6, 7, 8 years, and we could restore the 2003 rules on the ground that it was not in conflict with the 1981 rules. May I read it, Lordship? Paragraph 54 and 56. Again, in A.B. Krishna Supreme Court referred to Article 309 of the Constitution of India, held that it was primarily the legislature, namely Parliament or the state legislature, with whom power to make law regulating the recruitment and condition of service of persons appointed to public service and post in connection with the affairs of union or state is vested. The proviso, however, gives power to the president or the governor to make service rules, but this is only for transitional proviso, as the power under the proviso can be exercised only so long as the legislature does not make any act whereby recruitment to public posts, as also other conditions of service relating to that post were laid down. However, the rulemaking functions under the proviso to Article 309 of the Constitution is a legislative function. Elaborating further, the Supreme Court held that under the scheme of Article 309 of the Constitution, once a legislature intervenes to enact a law regulating the condition of service, the power of the executive, including the president or the governor, as the case may be, is totally displaced on the doctrine of occupied field. Power under 309 cannot be exercised by the governor if the legislature has already made a law and the field is occupied. In that situation, rule can be made under the law so made the legislature and not under Article 309. Rules made in exercise of the rule-making power under an act constitute delegated or subordinate legislation. but the rules under Article 309 cannot be treated to fall in that category, and therefore, on the principle of occupied field, the rules under 309 cannot supersede the rules made by the legislature. However, if any matter is not touched by that enactment, it will be competent for the executive to either issue executive instructions or to make rule under Article 309 in respect of that matter. This is what is the exception. If a particular aspect is not touched by the legislation, in that case, under 309 or by the executive instruction, that is under Article 162, it can be done. Paragraph 56. Supreme Court has, however, clarified that though non-statutory rules cannot modify statutory rules, there is nothing to prevent the government from issuing administrative instructions or frame rules under the proviso to Article 309 on matters in respect of which the statutory rules are silent. In my humble submission, how the government will consider a proposal, that particular area is silent. In that area, we have constituted this joint scrutiny committee. And therefore, it is not in repugnant, this is not in conflict with any of the provisions of the 2017 Act and the rules framed thereunder. So when the statutory rules are silent, we can interfere by how? By issuing administrative instructions. These 2019 and 2022 are administrative orders. I would like to place another judgment. 2011, 5 SCC, page 214. That was a big challenge how to restore 2003 rules. It was a very long exercise of litigation. The state government also pursued, and we could learn lots of things in that whole hearing. What are these departmental circulars? 2011, 5 SCC, page 214, Paul Manoj Pandian versus P. Veldurai. Paragraph 45, 46, up to 48. Departmental circulars are a common form of administrative documents by which the instructions are disseminated. Many such circulars are identified by serial numbers and published. Many of them contain general statements of policy. They are therefore of great importance to the public, giving much guidance about governmental organization and the exercise of discretionary power. In themselves, they have no legal effect whatever, having no statutory authority, but they may be used as a vehicle in conveying instruction to which some statute gives legal force. Here, pausing here for a moment, the statute says that the government will consider the proposals recommended by the state level committee. How it has to be done, we'll take the cue from this. But this may be used as a vehicle. So our 2019 and 2022 notifications will act as a vehicle in conveying instructions to which some statute gives legal force. That consideration by the state government. The government has the statutory backing of the provisions of subsection 7 of section 13 of the 2017 Act. So government can have to consider that has the legal backing. So how we can do it? We can issue departmental circulars which will act as a vehicle for in conveying instructions to which some statute gives legal force. It is now the practice to publish circulars which are of any importance to the public and not for a long time there has been no judicial criticism of the use made of them. Under Article 162 of the Constitution, the executive power of the state extends to matters in respect of which the state legislature has power to make laws. Yet the limitations on exercise of such executive power by the government are twofold. First, if an act or law has been made by the state legislature conferring any function on any other authority, in that case, the governor is not empowered to make any order in regard to that matter in exercise of his executive power, nor can the governor exercise such power in regard to that matter through officers subordinate to him. Pausing here for a moment. By administrative orders, the government cannot do anything to supersede or act in a special way regarding the functioning of the district level committee and the state level committee. In those areas, these administrative orders cannot be passed. That will be ultra virus to the constitution. But in other areas, it can. Secondly, the vesting in the governor with the executive power of the state government does not create any embargo for the legislature of the state from making and or enacting any law conferring functions on any authority subordinate to the governor. So this joint scrutiny committee is an authority constituted by the governor to act on behalf of the state government. 47. Once a law occupies the field, it will not be open to the state government in exercise of its executive power under Article 162 of the Constitution to prescribe in the same field by an executive order. However, it is well recognized that in matters relating to a particular subject, in absence of any parliamentary legislation on that subject, the state government has the jurisdiction to act and to make executive orders. The executive orders of the state would, in absence of legislation, extend to making rules or orders regulating the action of the executive. But such orders cannot offend the provisions of the Constitution and should not be repugnant to any enactment of the appropriate legislature. Subject to these limitations, such rules or orders may relate to matter of policy, may make classifications and may determine the conditions of eligibility for receiving any advantage, privilege, or aid from the government. So this is precisely what we are doing, provincial making them government sorted. 48. The power of the executives are not limited merely to carrying out the laws. In a welfare state, the functions of the executives are ever widening, which covers within their ambit various aspects of social and economic activities. Therefore, the executive exercise powers to fill up gaps by issuing various departmental orders. So we are basically filling up the gap. The executive power of the state is coterminous with the legislative power of the state legislature. In other words, if the state legislature has jurisdiction to make law with respect of the subject, the state executive can make regulations or issue government orders with respect to its subject, however, to the constitutional limitation. Such administrative rules and or orders shall be inoperative if the legislature has enacted a law in respect of the subject. Thus, the High Court was not justified in brushing aside the government order dated 16/11/1951 on the ground that it contained administrative instructions. So that line is not important. Otherwise, Lordship, when the field is not occupied, basically the meaning is very clear. We can do administrative orders to fill up the vacancy so that a uniformity is maintained. And the Assam Rules of Executive Business also says, Rule 10, that finance department's involvement in any creation of posts, any payment of emoluments and salaries, it is required to have a consultation. And that has the backing of the Constitution. Power under Article 166, 2 and 3. So these are the basic things, Lordship, on the point of law. Now coming to the factual aspects, actually I should have started the fact, but facts are very clear. Two discrepancies has been found. Whether the joint action committee, joint scrutiny committee has the authority to interfere or not. And review basically. And on top of that, government, the joint committee has not rejected till their proposal till now. If something is not coming satisfactory, then government will definitely take a call not to issue the notification. But till now, the effort is to get clarification, which is under the terms and reference of the notifications, that clarifications can be received. And if it is clarified, because very few cases Lordship is handling. We have already provincialized about 45,000 persons under this 2017 Act. So very few cases, because it is prima facie clear that proper signature or proper dates are not mentioned. Date is very critical. There is a timeline regarding their service. So that for that timeline also, it is required. On the other hand, the number of enrollment, that is also very important. It is a very crucial eligibility criteria. The statute prescribes a certain number of students must be there in the class if the teacher has to be regularized or provincialized. So those things, very basic facts. When there are two opinions coming from them only. One says plus X, one says minus X minus something. So which does not qualify them. If the report had been obtained in terms of the eligibility criteria, that they would not have the occasion to come before this honorable court. And in our affidavit, we have very categorically stated why we have done it, what are the requirements. We have filed two affidavits. In Lordship will take Polnath's case 6997. Paragraph 4. That under the Assam Education Act 2017, once recommendations for provincial.
Which one you were reading, first one or second one?
I am reading the first one that was written. Page 109. 104.
Okay.
Lordship will kindly come to page 106.
Yes.
Under the Assam Education Provincial Act 2017, once recommendations for provincialization are received from district level scrutiny committee and state level scrutiny committee are received in the favor of a teacher of answer educational institution for provincial, the administrative department, that is the education department, start the process for endorsement of the proposal for creation of post to the finance department in respect of the recommendation for provincialization of the services of teachers to the state level scrutiny committee for program. The finance department, which is the authority of creation of posts, has prescribed checklist and has specific conditions which are to be fulfilled, including ascertaining the financial implications, fixation of different scales and grade pay, ensuring that the eligibility conditions for the proposed post are fulfilled and the recommended teachers are fully eligible to hold the post of teachers or tutors as the case may be, and to ensure that no error occurred in the process of recommendation so as to avoid any loss of public exchequer and to avoid a situation whereby the sanctioned post would be filled up by non-eligible persons. So this is a very basic requirement from the finance department. The Department of School Education and the Department of Finance constituted a joint team of officers and staff to fast-track the proposal, which are error-free, and also expediting the resubmission of the proposal where there are errors in calculation or shortcomings in assessing the eligibility conditions, etc., or in which there are lack of clarity in the proposal. That it is also observed that the recommendation of the DSLC and the SSLC, sometimes due to huge load in dealing or processing the recommendations for teachers who had applied for provincialization, would at times are in ensuring that only eligible candidates were recommended or at times failed to clearly reflect the eligibility of persons recommended for provincialization. Such a situation had led to delays in post-creation process and anomalies act as a barrier in completion of the process of provincialization. The government, having the experience during the past while provincializing the teachers under erstwhile statutes, and therefore to ensure a smooth process during implementation of the provisions of Act of 2017, and in order to remove difficulties and delays, the joint committee was formed with representatives from Finance Department and Department of School Education to rectify the errors in documents and relevant papers prior to being endorsed to the post-creation branch of the Finance Department. Finance Department has various departments within finance, so as to ensure that the concurrence for the creation of post is accorded smoothly and swiftly without any errors. That the very purpose of joint committee was to fast track the process of provincialization and to ascertain whether necessary documents, papers which are enclosed with the proposal are as per requirement in order to make the process error-free prior to submission of the proposal to the finance department for creation of post. The joint committee was initially formed by notification of 27 January 2019, and same was reconstituted on 2014-9-2000 in pursuance of administrative reforms, training, pension, and public public grievance notification dated 12. So next two paragraphs are also there. Basically, there is no conflict which we are saying. And also another additional affidavit we have filed. Paragraph 4, 3 and 4. The deponent humbly begs to state that section 13(7) of the Assam Education Provincial Teachers and Reorganization of Education Act 2017 states that the district scrutiny committee shall forward the list of eligible teachers based school-wise in accordance with the act. The concerned director, who shall place the matters before the state level committee to be constituted under subsection A of this section, and after making such further scrutiny as may be required, shall forward the same to the concerned department of the state government for consideration and for issuing notification in respect of the eligible institutions and eligible for getting their services provided. It has been clearly stated in section 13(7) of the Act of 2017 that the state government will take up the matter for the purpose of consideration. That word I am stretching again. For further purpose of issuing notification for provincial, according to the Black's Law Dictionary, means consider means to fix the mind on and to view a careful examination, to examine and to inspect. Consideration is not to be confounded with motive. Consideration means something which is of value in the eye of law, either benefit to the practitioner or to the respondent, taking account of the circumstances. To consider a matter does not mean to comply the order without careful examination or inspection. The Honorable Supreme Court in a catena of the judgment which I have already placed, Lordship can skip this. So we have basically elaborated the meaning of, I have already placed the Supreme Court Constitution bench judgment. 4 also says Assam Rules of Executive Business. The deponent humbly begs to state that in accordance with Rule 10 of the Assam Rules of Executive Business, no department shall, without previous consultation with the finance department, authorize any order other than orders issued by any act and so. It can be determinable that consultation with the finance department is a mandate, not a discretion. The
Okay,
department of
Mr.
finance.
Sarkia, you have already pointed out
Yes,
in the relevant rule,
yes,
rule of executive business.
absolutely.
No
Lordship.
need
So
to
these
read
are
out
part
it.
of the additional affidavit.
Yes, yes.
So my only one additional fact that already 45,000 teachers are regularized or institutions are with provincial level.
Hmm.
So in that situation, Lordship may not be pleased to interfere with the joint scrutiny committee notifications, because this will upset the whole system, which has already gone through a very lengthy process. Already about 95% of provincialization act is over. Few are left which have some errors in their proposals. They are left out, but otherwise it is an exercise which has already been conducted. In other words, I would say that it's a fait accompli almost. So in that view of the matter, in my humble submission, there is no merit in the petition. We have not rejected. We are just trying to get a clarification from the competent authorities, either the state level committee or the district level committee, and whatever final opinion comes from them, the government will act according. If everything comes in order, they will get the provincialization order. If it is not, then their proposal will be rejected. In that view of the matter, these cases are in fact, other than challenge to the joint committee, the other points, it is premature in nature. And Lordship has already passed an order for provision. We are doing that exercise. While we are doing the exercise, this clause has come into our notice. This is my humble submission. If any clarification, my colleague will be here, Lordship, if after their reply. Otherwise, my part is over.
Yes, Mr. Islam.
May it please your lordship. Lordship may kindly have the Act of 2017, Section 13, lordship.
Yes.
Section 13, lordship, prescribes constitution of district scrutiny committee separately for elementary, secondary and higher education, lordship.
Hmm.
Lordship, this
Section 13(4), secondary education, the district scrutiny committee is a 8-member committee under the chairmanship of district commissioner lordship. Their lordship will kindly get 13(7) lordship. May I read lordship? The district scrutiny committee shall forward the verified list of eligible teachers based school wise in accordance with the act to the concerned director lordship, who shall place the matter before the state level scrutiny committee to be constituted under subsection 10 of this section, and after making such further scrutiny as may be required. This expression is important lordship, shall forward the same to the concerned department of the state government for consideration and for notification, issuing notification lordship. That means there is a conjunction. The person, the authority who will consider the case will also notify and issue notification lordship. Here lordship, it is important, I will come lordship, that consideration and issuance of notification by the same authority. Here in the instant case, it is a state government under the appropriate department, that is Department of School Education lordship. Now lordship will find thereafter section 10, subsection 10, 13(7), the composition of the state level scrutiny committee lordship. It is under the chairmanship of director of the concerned department. In our instant case, it is director of secondary education. So director of secondary education is the chairman of the state level scrutiny committee. And lordship 13, subsection 12 lordship. When there arises difference in between the recommendation of the district scrutiny committee and the physical verification report caused by the state level scrutiny committee, the matter shall be placed before the state level committee and the decision of the state level committee shall be final. In so far as scrutiny and verification of document, these two committee is prescribed under the act to carry out the exercise of verification and examination of documents. It is final lordship. It is not that the state level committee decision of the state level committee will have the precedence or prevalence lordship. It is final lordship. The expression kindly lordship shall be final as opposed to preference or prevalence or lordship preference. It is final. So as far as document verification is concerned, these two committee will verify the documents and submit it before the government. Now government will consider and issue notification. Now as far as this expression section 13(7) is concerned, lordship, the exercise must be done by the government, not any other authority. The essence of this section 13(7), it doesn't indicate in any way that you constitute any other foreign body to consider the thing. In the instant case lordship, the joint committee, impugned joint committee is not government lordship. No stage of imagination lordship, the expression government comes to help the constitution of this joint committee lordship. Who are the joint committee as per affidavits filed by the respondent number 1 lordship? Is joint committee, the initial one lordship is the chairman Seva. Is the chairman Seva is the chairman of the joint committee. Now second one is Pritam Soikia, I as Commissioner and Secretary, Secondary Education Department, Finance Department, one additional secretary, and then Director of Secondary Education. So the whole purpose, as my learned senior friend indicated, and the mentioned in the affidavit lordship, whole purpose of constitution of joint committee is to make error-free exercise and expeditiously, Lordship. That is why it is stated that the committee shall submit its report within 7 days, Lordship. Now I am coming, Lordship. The director of secondary education is the administrative head. She is the director. She is also the chairman of the state level scrutiny committee. And here she is also the member of the joint committee. Now, all the exercise carried out by the state level committee under the chairmanship of director. Now she is also a member of the impugn joint committee, Lordship. So the same person is acting in 3 capacities as director, as the chairman of a state level committee, as well as member of the impugn joint committee, Lordship. So if the constitution of joint committee at all any relevance of having carry out the exercise error free, now how can the chairman of the state level committee is also a member of the joint committee? Now it is the famous expression, the no one can be judge of his own cause, Lordship. Now a joint committee will trace out the mistake or error committed by the state level committee by the chairman of that joint committee as acting as member, Lordship. Lordship, may kindly another point, Lordship. In the affidavit, Lordship, first one, affidavit filed by the respondent number 1 as page 112, Lordship, and exact 2, Lordship. The 14 September 2022 notification issued by the Secretary to the Government of Assam.
Yes.
Lordship will mark the expression partial modification of the notification so and so dated. Governor of Assam is pleased to reconstitute. The expression used here reconstitution, Lordship, as opposed to modification or something else, Lordship. Now, Lordship will see the terms of reference, Lordship. To examine the proposals received for provincialization of teaching staff of Hansar LP and recognized UP scholarship. Here, there is no mention of any secondary institution, Lordship. In our case, Lordship, we are higher secondary school, Lordship. So the impugn joint committee, Lordship, I'll come for further submission, Lordship, on the constitution, the validity of this committee. But even if we accept for a moment that these committee are valid, even then it has the mandate of examination of the proposal received from provincialization of teaching staff of Hansar LP and recognized UP. There is no mention, Lordship, of secondary institution, Lordship. Now, Lordship, one more point, Lordship. I have already stated, Lordship, the joint committee as may be constituted by this instrument, Lordship, is not the included in the expression of government, Lordship. A bare reading of section 13(7), it is clear that consideration and issuance of notification, and it is not that somebody else will consider and somebody else will issue the notification. So the exercise of issuance of consideration and issuance of notification by the same authority, and that is the government. And government in no stage of imagination come the expression joint committee. Now, Lordship, the earlier round of provincialization, when whose service have already been provincialized in the year 2021, Lordship, their case having cleared by the state level committee, it went to the government, and government placed the matter before the finance department for concurrence. And once the concurrence has been granted by the finance department, all the cases have been notified by government. As clear from Lordship, may kindly have a look again, Lordship. I am traveling, Lordship. 106 of the affidavit filed by the respondent number 1, Lordship. I just want to pass out the relevant portion only. Para 4, Lordship. Once recommendation of for provincialization are received from district level scrutiny committee, state level scrutiny committee are received in favor of a teacher of venture educational institution for provincialization of so. The administrative department starts the process of endorsement of the proposal for creation of the post to the finance department. So my learned senior friend referred that it is mandatory that you have to submit the file to the finance department, and no order anything will pass without submitting the matter before the finance department. So finance department will always, education department will always endorse the file before the finance department for concurrence. Once the concurrence received, the state government will issue notification. This is the mandate of the act, as admitted also by under section para 4 of the affidavit. Now, earlier round of cases, as my learned senior friend indicated, that huge exercise was carried out. In those cases, there was no placing the matter before the joint committee. Now, our case, why we are before this honorable court, Lordship? Because in my case, Lordship, my enrollment is 11. As per Act, 10 required, 10 or more, Lordship. As reported by the chairman, controller of examination, Assam Higher Secondary Education Council, my enrollment is 11. Now, what the state level committee did, Lordship, they have obtained a report from the chairman Seva, Lordship. This chairman Seva doesn't have any business to do with the higher secondary classes. In our case, it is higher secondary first year and second year. Now, Chairman Seva reported that I have 6 enrollment. Subsequently, when we submitted representation and state level committee obtained reports and all these things, state level committee recommended my name way back in the year 2022 and submitted before the government for creation of post along with 53 others, Lordship. Now, once the director submitted the proposal for creation of post, Lordship, the ideal way of the things would have been government to consider. There is no denial that you blindly accept the recommendation of the state level committee. Nobody is claiming that. The government is helpless before the state level committee recommendation. You find it. You examine everything, you do everything. Nobody is denying. Nobody is claiming any that nobody is developing any argument that the government doesn't have any power and government is duty bound to the recommendation made by the state level committee. But it has to be done by the government, not by creating or reconstituting another body, Lordship. Whatever body is envisaged under the Act, Lordship, those are sufficient 2-layer body. Now, those.
Okay, we'll resume at 2.
Lordship.
I have one meeting at 1:15. So.
May I please your lordship? Lordship may kindly pass over the matter, pass over item number 24 for the day.
Okay. You are for the respondent?
Petitioner, your lordship. Yeah, I am for the respondent, sir.
Any objection? No.
No, Your
That's agreed by. Okay. When do you want?
Lordship, 31st March.
31st March. Okay.
Obliged, lordship.
May it please your lordship. Lordship, as my learned senior friend emphasized on consideration, lordship, as appeared in section 13(7), lordship. Lordship, the government, it is the government and government only can consider and issue notification. It is admitted fact that issuance of notification is the job of the government. So also the consideration, lordship. It is the government who is to consider the recommendation of the state level committee in terms of section 13 within bracket 7, lordship, of the act, lordship. Now, while considering, lordship, the government must have arrived at a findings that certain recommendation are not in accordance with the provision of the act, and there must be some reasons to be recorded. It is not automatic. It cannot be automatic that a state level committee submit the proposal before the government, and government, without applying its mind, will send back to the joint committee. In the instant case, lordship, affidavit, 2 affidavits filed by respondent number 1, and there is not a iota of any whisper to address this issue. Whether government has considered, whether government has found some inconsistency in the SLHC recommendation, who is necessitated to send the or to constitute another foreign body to be and thereafter there must be some subjective satisfaction of the government that out of this and that number of recommendation, so and so recommendation are inconsistent. So out of this recommendation, those which are inconsistent may be considered. I am not admitting, but assuming there is no such a statement in both the affidavit that the government has considered and they have arrived at a finding that certain recommendations are not so and so inconsistent with the act. So they have decided to verify further. In that circumstances, a joint committee or something has been constituted. There is no such total silent, lordship. It cannot be automatic. Cannot be automatic, lordship. Where is the application of mind by the government? There is no application. I'll show, lordship, that the state level committee in its meeting held in the year 2022, they have recommended the case of 54 persons. I'll show, lordship. In my affidavit, in my writ petition, the records are there. These 54 totally sent back to the joint committee, lordship. It cannot be. The state level committee recommended 54. The director of secondary education forwarded the case to the government for creation of post. And now government sent back all the 54, lordship. So where is the consideration, lordship? And where is the application of mind? Application of mind must be by government. And ordinarily, what we mean by the expression government, lordship, is the secretary, is the commission secretary, maybe joint secretary, assistant secretary, and not some foreign body who is
Lordship, the joint committee headed by chairman of SEBA is the retired bureaucrat. Is the retired bureaucrat, Lordship. There is no consistency in between the consideration by government and consideration by joint committee, Lordship. Lordship, what happened, Lordship? Earlier in the year 2018-19, Lordship, the district level committees made recommendation school wise as provided under section 30. Those recommendations were scrutinized by the state level committee and cleared by them. In one go, service of several thousand employees were provincialized without sending the matter to the joint committee or without, to be true, Lordship, nobody has been re-verified the recommendation made by the state level committee.
When?
Nothing, because once the state level committee recommended name, it sent to the government. Government might have applied its mind, and after application of mind, Lordship, it it forwarded the file to the finance department for concurrence. When the finance department issued its concurrence, Lordship, those services have already been provincialized in the year 2024 to 2021. But those whose service were not recommended by the state level committee, now we are in trouble, Lordship. So what the government have done, Lordship, government have created a class within a class, Lordship. Those whose service have already been provincialized in the year 2021, and we are in the same footing, Lordship. There is no difference, Lordship. So in earlier round, Lordship, they have directly provincialized their service without sending it to the joint committee, Lordship. Now in our case, they have again and again, Lordship, I'll show, Lordship, 3-4 round of joint committee sending it back for verification and re-verification. I'll show, Lordship. So there is a violation of Article 41 and selective provincialization is being done, Lordship. There is a selective provincialization. Same group of person, a group of person out of the same group, Lordship, are provincialized, but we are not being provincialized. There is selective provincialization in violation of Article 13 of the Constitution. Government cannot treat similarly situated person differently and different persons similarly, Lordship. So in the instant case, it is face of the record, I'll show, Lordship, that government is treating similar person differently, Lordship.
Mr. Kaushik, is it correct that in the year 2021 and 2022?
No, actually it is incorrect, Malad. There is no, Malad, I don't know what is the material source of information from which this argument has been made, Malad. Because joint committee was framed constituted in 2019, and the first provincialization drive, Malad, the finalization was done on 4th of February 2020. So that was the first day when the provincialization of all the teachers, earlier teachers were done, with effect from 1/2/2020. The notification was issued on 4th of February 2020.
No,
So prior
is it,
to that, the joint committee was constituted.
okay, is it your case that each and every matter of provincialization was placed before the
Yes.
joint committee?
It is when the, Malad, your lordship will kindly see, your lordship will get the hint from page 53, Malad. Page 53 of this 6997.
Yes.
This is a submission or proposal for creation of 54 numbers of posts of provincialization by the director to the secretary. Now the power under 13(7) for consideration by the government that is being done by the joint committee. Well. So it is the moment the state level committee places it before the government, my lord, it goes to the joint committee. Joint committee and exercises the power of consideration. And thereafter, my lord, based on that, it is sent to the finance department. And my lord, this argument, my lord, is not based on any materials on record, my lord. There are no pleadings also, my lord. In my affidavit, there's no denial to that affidavit, my lord. There's no reply file.
Lordship, in fact,
So,
joint
what is-
committee constituted lordship in the year 2022, lordship.
No,
No,
in
19.
19. First it was
19,
constituted-
that is not, no, lordship. Lordship, there is no word joint committee, lordship.
Hmm.
May I read? The governor of Assam is pleased to constitute a committee as mentioned below to examine the cases for provincializing the service of the teaching staff of educational institution under the provision of the Act 2017 as amended. Nowhere it is mentioned that joint committee. And lordship, in our case, lordship, this my learned friend thankfully referred page 53 of my writ petition, lordship, where out of these 54 posts, those who are recommended by the state level committee, sent back forwarded to the secretary to the government of Assam. Lordship, all the 54 have been put before the joint committee, and joint committee is again and again verifying and re-verifying. I'll show, lordship. Now, earlier, those service whose service have already been provincialized on 4/2/2021, lordship. Their cases were not scrutinized, subjected to such vigor scrutinized, lordship, of putting the before the joint committee, lordship, after having recommended by the state level committee, lordship.
In which paragraph of your petition you have mentioned it?
No.
No pleadings.
I have stated that joint committee again and again verified our case, lordship. Lordship, it is clear, lordship. Since 2018, the recommendation made by the state level, district level committee to the state, after clearing those recommendation, lordship, the provincialization have been made on 4/2/2021, lordship. But once the joint committee come in the play, lordship, since 2021, lordship, we are sitting in 2026. So thanks to that impugned joint committee, lordship, once it gets report from the district school committee, it again, government again places there before the joint committee. Joint committee says that no, this time we will say independent authority. Now it is first district committee, lordship, that is 8 members committee headed by district commissioner. Second time they again said that it should be re-verified by the district commissioner, chairman of the district committee. And once that is done, lordship, joint committee again say that you have to get it re-verified by an independent authority and requested the district commissioner to appoint somebody, lordship. Most cases, circle officers have carried out that exercise, genuineness, lordship. So initially 8-member committee, subsequently 1-member committee, and subsequently, lordship, an officer, circle officer subordinate to the district commissioner, lordship. So by this way, lordship, we are suffering since 2021 to 2026, lordship. So initially had there been similar treatment, so they could not have provincialized their service, thousands of employees service in the year 2021, lordship. There is no vigor of this examination by the joint committee at that time, lordship. Now, once lordship,
Mr. Islam, you see, this committee was constituted in the year 2019.
Lordship.
And according to him, all the matters of provincialization was placed before the state committee after the same being recommended by the state level committee.
Yes.
You were submitting that selectively they have placed the
No,
matter before
what
the
I am
committee.
submitting, Lordship,
So, where is the material to support your contention?
what I am submitting, Lordship, I could may not have make a clear submission, Lordship. They have done it. We are not denying, but joint committee, some committee was constituted in the year 2019. But those exercise was mostly carried out by government. Might have this joint person of this committee might have checked and verified, but for one time, and thereafter they have cleared and their service have been provided. But in our case, Lordship, government again and again placing the matter before the joint committee. So that what I wanted to submit before your Lordship. Now, Lordship, in section 13 within 7, Lordship, there is expression, consideration and issuing notification, Lordship. Lordship, I have already shown that this Rule 10 of the Assam Rules of Executive Business 1968, Lordship, on which my learned senior friend has extensively argued, Lordship, is that it is mandatory in part of the any department to refer the matter to the finance department before issuance any order, Lordship. Here and page 116 of the affidavit,
Yes.
para 4, Lordship. The deponent humbly begs to state that in accordance with Rule 10 of the so-and-so, no department shall without previous consultation with the finance department authorize any order so-and-so, so-and-so, so-and-so. Now, Lordship, may kindly come page 106. It essentially says that once the district committee and state level committee recommended in favor of a teacher, the administrative department starts the process of endorsement of the proposal for creation of post to the finance department in respect of recommendation for provincializing of service of teacher and so and so. A state level scrutiny committee for provincialization. So already there is a mechanism, Lordship, for mechanism that after the state level committees submit the proposal before the government will resend to the finance department for obtaining concurrence. Once the concurrence is obtained, Lordship, the government issues notification provincializing the service of teachers, Lordship. So there is no question except of Rule 10 of Assam so and so to constitute a foreign committee, Lordship, which is not envisaged under the Act, Lordship, to examine the recommendation made by the state level committee, which is final, Lordship, as per section 13 within bracket 12, Lordship. Now, my learned friend further argued on doctrine of occupied field, Lordship. In my humble submission, Lordship, there is no gap, Lordship. The Act 2017 is absolutely inclusive of all the exercise to be done by the authorities in provincialization service of the teacher, Lordship. So my humble submission that no application of doctrine of occupied field in the instant case. The Act of 2017 is not silent. It is exclusive, Lordship. Under section 13, Lordship. Lordship, what happened in my case, Lordship? My case has been recommended by the district committee 2 times, state level committee 3 times, and independent authority 1 time, Lordship. Even after doing all the exercise all along consistently, they have recommended my name for provincialization of my service. So what the state joint committee, impugned joint committee is doing is, Lordship, is sitting over the recommendation made by the state level committee, for which Lordship may kindly come to my read petition for a moment, Lordship. I'll quickly go through, just show the relevant portion, Lordship.
Your,
My read petition.
okay. Paragraph number?
No, rather I'll page number, Lordship.
Yes.
Page number 38, Lordship. Lordship, may I peruse page 40. 40 is the vernacular portion, Lordship. My service was not provincialized because as per their finding that I have 6, but this is the school record, Lordship. Lordship will get 10 and 11, Lordship. Bottom, Lordship. Got it, Lordship. So my subject is history, Lordship, top history, and my enrollment is 11, Lordship. Thereafter, the controller of examination, Lordship, page 41.
38, your serial number is that?
My serial number is, my subject is history, Lordship.
History, yes.
History. 39, it is 11, Lordship, total, grand total. Those
11.
are roll numbers,
Serial number 11.
Lordship. Page 39, 11 is there, Lordship.
No, in page 38.
39, Lordship. 9th column, Lordship. Start with 50, Lordship, 50. Lordship, got
Serial
it?
number.
Yes, 50. Column number 9, start with 50, then there's 2 gap, then 11, finally 11, Lordship. Lordship, may also peruse the vernacular one, that will clarify, Lordship. Page 40, Lordship. This is the school record under the signature of principal and principal of college, Lordship. Lordship, got it? Total in the
Page
bottom,
number.
Lordship, 11. Now, Lordship, page 41 may kindly be perused for a moment, Lordship. The controller of examination reported to the principal that history in the year 2016 is 11, Lordship. Now the director fought for a report from the controller of examination, secretary, Assam Higher Secondary Education Council, and finally, Lordship, kindly peruse page 46, Lordship. Page 46, I am serial number 2, Lordship. My subject is history, Lordship. Number of candidates received from so and so 10, and number of candidates received through Chairman Seva 06. Now, this is the reason for why I am suffering, Lordship. In higher secondary classes, Lordship, Seva has nothing to do. How is SEBA, it is Higher Secondary Education Council only. Who will report the examination of the candidate appeared in the particular year, Lordship? They have obtained it through Chairman SEBA. This led to my misery, Lordship. Now, Lordship, page 53. Page 53.
So who is the proper authority to give this?
Assam Higher Secondary Education Council. And accordingly, Assam Higher Secondary, page 41, reported that I have 11. School record also show that I am 11. Page 53, Lordship.
Page
53. So, as the state level committee obtained report from SEBA, Lordship, which is incorrect one, that too from the incorrect body, not relating to higher secondary classes, Lordship. So my name was not recommended by the state level committee. Thereafter, I have submitted all the documents as sought for by the authorities, and authorities placed the matter before the state level committee, and state level committee recommended my name, and by letter dated 12/7/2022, page 53, Lordship. Cases of 54 persons were submitted before the government for creation of post, Lordship. 54 also includes me, I'll show you later on, Lordship. Now, page 54 may kindly be page. Last paragraph, Lordship. Therefore, the government is requested kindly to accord sanction for creation of post of total 54 numbers of teaching staff of secondary schools which are eligible for provincialization under the Act of 2017 indicated so and so, so and so. So out of these 54 which were recommended by the state level committee, all those persons are forwarded to the government. What the government has done, Lordship? Government, Lordship, page 59. Government placed the case of all the 54 before the joint committee, Lordship. Page 59. No, place the matter before the government. Government placed the matter before the joint committee, and joint committee again decided to verify from the chairman district. Second paragraph, Lordship. Now the joint committee has decided to re-verify the proposal from the concerned chairman district scrutiny committee. So director wrote to the inspector of school to place the matter before the chairman, distant chairman. Now this 54, Lordship. So subsequently, the district level committee chairman, Lordship, has recommended my name again, Lordship. Page 62 to 64, Lordship. Thereafter, Lordship, what happened? After on receipt of district scrutiny committee recommendation by the director, Lordship, the matter placed before the state level committee. Lordship, page 78, annex 15, one paragraph. With reference to the subject cited above, I have the honor to state that as recommended by the state level scrutiny committee. So cases of this person annexed with the letter, Lordship, their case have already been recommended by the state level committee. Now what happened? The state level committee, joint committee recommended in its meeting held on 11/10/2023 has opined that for further proper verification, second time lordship, the impugned joint committee is sending matter, even after recommendation made by the state level committee. So the director requested the district commissioner to submit genuineness report from by an independent authority in the field level lordship. Those exercises have already been done in the year 2024 lordship. Now thereafter lordship, what happened? The independent committee genuineness report was submitted before the director, and director on that basis lordship prepared a report lordship. Lordship, page 85 lordship. My serial is 48 lordship. Column number 10 lordship. Earlier the enrollment report was shown as 06 Seva lordship. For the year 2016, later as per report obtained from the Assam Higher Secondary Education Council, enrollment for the year 2016 is found to be 12, hence may be considered for provincialization. Now, once this provincialization has been recommended, government again placed the third time, placed the matter before the impugned joint committee. Now the impugned joint committee resolution, page 89 lordship. The committee discussed the matter concerning provincialization of so and so, so and so. The services of so and so, so and so, and so and so were not provincialized earlier due to non-fulfillment of requirement enrollment of students in their respective subject. On the basis of fresh report regarding enrollment data received from Assam Secondary School Education Board Division 2, the state level committee recommended the names of so and so, so and so, and so and so. Now, who is this Assam Secondary School Education Board? Is the chairman of the joint committee lordship. This is the same person. Now, report obtained from whom lordship? Previously it is Assam Higher Secondary Education Council, now Assam State School Education Board. Chairman of who is the same person who is also chairman of joint committee. Now, on the basis of report obtained from the Assam Higher Secondary Education Council lordship or Education Board, my name was recommended by the state level committee. Now, the very same person is saying that now, joint committee must have decided to verify the proper reason for how to enrollment data can be changed. Lordship, my humble submission is that I do not have any objection to the inquiry investigation, whatever my learned friends are doing since last 6-7 years. I do not have any objection. Let my services provincialized. Subject to, I am ready to give an undertaking that in the event my enrollment is found below 10 lordship, I am ready to forgo my rights and all these things I will submit. But for God's sake, lordship, one person cannot be subjected to search for torture for last 6-7 years. Lordship, may kindly page 100 lordship. In an earlier proceeding lordship, this honorable court had the occasion of examining the validity of joint committee lordship. Now, on the basis of letter issued by the Secretary lordship to the Government of Assam Department of School Education, para 10 lordship. This court, in view of the provision of the Act 2017, holds that the said committee is not a committee envisaged under the Act of 2017 thereof. Is a clear finding of this honorable court. This honorable court held that joint committee is not a committee envisaged under the Act 2017. Lordship. Now, Lordship, I am agreed by the recommendation of the joint committee. Lordship. Apart from, I have challenged that very constitution of joint committee. I have also challenged the resolution 8, Lordship. By which, Lordship, even after the case of the petitioner was recommended 3 times by the state level committee, the joint committee decided to verify the reason. Now, I have already shown your Lordship that the very person who is holding the post of chairman of this education board, Assam Secondary School Education Board, is the same person who is also chairman of joint committee. Now, after receipt of report from that body, Lordship, education board, state level committee recommended my name. Now the same person, Lordship, again saying that we have to verify the reason. Meaning thereby, this joint committee is telling that we have to verify the action of our chairman himself. Because on the basis of report from education board, state level committee recommended my name. Now, firstly, joint committee cannot override state level committee. Secondly, even if assuming for the sake of argument, Lordship, now who will examine, who will find out the fault of the chairman himself? The same very person. Again, coming the principle of one would be the judge of his own cause, Lordship. These are nothing, Lordship, only to delay the cause, Lordship. So from the above, Lordship, which I have respectfully submitted before your Lordship, is that I am a person eligible in the year 2021 itself. There is no difference between my colleague and me. I have shown your Lordship school record. Those are prior to 17, 18, Lordship, 16. In fact, 2014, 15, and 16. So it is abundantly clear that I was eligible in the year 2021 at par with my colleague, Lordship. So the entire exercise carried out by the respondent authorities are arbitrary and illegal, Lordship. So I am entitled to get my service provincialized, Lordship, at par with my colleague, Lordship. That is with effect from 30/11/2021, Lordship. In page 44, annexure 7, Lordship, the service of other PGT of our school have already been provincialized on 30/11/2021 with immediate effect, Lordship. So my prayer would be, Lordship, for a direction to provincialize my service at par with my colleagues, Lordship. This is my humble.
Yes, my lord, in respect of item number, my lord, 1, my lord, WPC number 6870/2025. I will, my lord, take, my lord, 5 to 7 minutes, my lord. Now, my lord, I would like to, my lord, revisit the section 13(7) and section 2R, if your lordships kindly see. Section 13(7), first, my lord. Yes.
Yes.
Yes, lordship has seen, my lord, section 13(7). The district committee shall forward the verified list of the eligible teacher based school-wise in accordance with the act to the concerned director, who shall place the matter before the state level scrutiny committee to be constituted under subsection 10 of this section, and after making such further scrutiny as may be required, shall forward the same to the concerned department of the state government for consideration and for issuing notification in respect of the eligible institution and teachers eligible for getting services provincialized. Now, lordship, kindly see section 2R. What is the, my lord, government? It will be Lord, section 2R, lordship, kindly see. Lordship got it. Section 2R. The state government means the state government of Assam in the concerned education department, elementary education department in case of primary and upper primary schools, secondary education department in case of secondary higher education schools, and junior colleges, higher education department in case of degree colleges. Now, after the various process has been concluded, matter has to be referred to the state government. Government is defined here, state government. Now, in respect of elementary, the commission secretary, elementary. In respect of secondary, the secondary education commission secretary. Now, they are not referring the matter to the appropriate authority as mandated by the act. They have referred the matter to the extra committee, which is not under the provision of the act. So, my respective submission, my lord, my learned senior counsel, the AG has submitted that there is a vacuum in the field of the act. There is no vacuum. It is specifically clear. This is the mandate of law. You are go by the mandate of law, not by this way or that way. So, lordship, kindly note, my lord, section 13(7) and, my lord, section 2R, specifically clear, my lord. The joint committee has no role in this matter, my lord. Now, secondly, my lord, lordship, kindly see the power under which the, my lord, committee has been constituted. Lordship, kindly, for the moment, my lord, section, sorry, my lord, article 154 of the Constitution of India. Now, I will not go by the 162 and 166. That is there. We have no problem. But article 154 says, lordship, kindly see. Executive power of the state. The executive power of the state shall be vested in the governor and shall be exercised by him, either directly or through officers subordinate to him in accordance with this constitution. No problem. Now come, lordship. Nothing in this article shall be deemed to be transferred to governor any functions conferred by any existing law. Pausing for a moment, my lord. Now, here is a case, my lord. There is a statute, there is a mandate of law, existing law in our hands. So, the joint committee, as referred in the, my lord, affidavit filed by them, has no, my lord, locus. In fact, this has to be, my lord, read with, my lord, section article 162 and 166, my lord. Now, apart from that, lordship, kindly see the next provision, lordship, kindly see section 4 of the act. Section 4 of the act, lordship, kindly see. I will just summarize, my lord. Section 4. Subject to fulfillment of all other provision of the Act, the services of the teachers and the tutors of all Bensar education institution eligible under Section 3 shall be deemed to have been provincialized on the date of publication of the provincialization order by notification in the official gazette, and they shall become employees of the state government with effect from such date. Now, Section 4 says, my lord, regarding the certain criteria laid down in the Section, my lord, 3 of the Act. Now, Lordship, kindly see for, my lord, Section, my lord, 3(1) first, my lord. 3(1). These are the conditions prescribed under the Act, my lord. Section 3. Roman 1. Lordship will find last line. Instruction from the respective competent authority or authorities on or before 1/1/2006. That is the, my lord, one of the condition. Then, my lord, Roman 2, Section 3, my lord, Roman 2, Lordship will find land, building and other infrastructure. These are the condition. Then, my lord, Roman 4, 5, 6, enrollment, etc. Other infrastructure. Now, Lordship, kindly see Section, my lord, Roman 12. Section 3, Roman 12, my lord. May I read, my lord? 2-3 lines, my lord. The enrollment shall be verified with the database dice code number so and so for available records of the National University Education Planning and Administrative, New Delhi. There shall be a physical verification of the students and checking of the records of the attendance of the students of the last 3 years. That is the one of the condition, my lord. Then, Lordship, kindly see the final authority, my lord, under, my lord, clause 6. Certain condition has been laid down. Clause 6, Roman 3, my lord. Yes. 6A, my lord, first 6A, then, my lord, Roman 3. Lordship got it. At least one high school or high madrasa within a radius of 5 kilometers. These are the, my lord, condition prescribed under the Section 3. And so far the Section 3, 4 is concerned, my lord. These are has been, my lord, evaluated under the, my lord, statutory body, district level scrutiny committee and state level scrutiny committee. Now, in my case, my lord, specifically, what has been, my lord, done to the petitioner, Lordship, kindly see for a moment how they are, my lord, deprived from time and again. Now, first, Lordship, kindly see at page 55. Page 55. This is, my lord, writ petition number 6228/2012. Now, operative part, Lordship will find at page 56, order dated 19/3/2013. I will just, my lord, read out the relevant portion, my lord, paragraph 3, my lord. Page 56, paragraph 3. While the case is pending, the district scrutiny committee advises under Section 10. Now, under the old Act, my lord, it was Section 10 of the Provincialized Act, have scrutinized the claim of the petitioner for provincialization of benefits. Accordingly, Mr. So-and-so, since the district level committee, DLC, has scrutinized the claim of the petitioners, madrasa, the matter may be referred to the state level scrutiny committee, SLC, for appropriate decision, and the SLC should be permitted to take a decision on merit. Mr. So-and-so, appearing for the petitioner, is agreeable with the submission made by the government lawyers. Then next, my lord, in view of the above and since the agreements or grievance of the petitioner is now to be considered by the higher committee, the SLC may give their decision expeditiously and preferably within 8 weeks from today. If the petitioner is aggrieved thereafter, they may reapproach the court. Now, in the year 2012, Lordship has seen 13, the first order, my lord, under the 11 Act, my lord. Now, 11 Act, my lord, is declared unconstitutional by the Honorable Court. Then 17 Act comes. Now, under the 17 Act, Lordship kindly see first resolution, our recommendation at page, my lord, 59. Page 59, Lordship will find this is the, my lord, a District Scrutiny Committee report dated 16/2/2019. Our party part, Lordship will find at page 60, serial number 26. Name of the school, my lord. Lordship got. Yes. Then, my lord, the recommendation part, Lordship will find page 61. Page 61. Now, here some, my lord, teaching staff has been recommended and some has not been recommended. And ultimately, they made an appeal before the appropriate authority. And finally, they, my lord, recommended the name of the petitioners as reflected in the, my lord, final, my lord, scrutiny report. Lordship will find at page 80. Page 80, Lordship will find first the minutes of the District Scrutiny Committee meeting held on 3/4/2023. Lordship will find below, my lord, the name of the school, my lord. Lordship will find serial number 2, then 1. Eligible teaching staff of Nasir Mundal Memorial High Madrasa. Lordship got it. Yes. This is on, my lord, 3/4/2023. Then Lordship kindly see again another scrutiny committee report on re-verification of authentication of the original documents. Page 81. Page 81, Lordship will find dated 12/4/2023. Name of our school, Lordship will find in, my lord, paragraph 5, my lord. The school documents, including the land documents, so and so school, have been examined and found in conformity with the provisions of the Act, so and so provision of existing staff. The post of headmaster is lying vacant. The following teaching staff are found eligible for provincialization. These are all petitioners, my lord. Then Lordship will find the annexer portion they have referred. Name of the, my lord, petitioners, Lordship will find at page 86. These are the teacher's name and the school's name. Lordship has seen. Page 86, my lord. Yes. Then, my lord, the earlier in between, my lord, there was an order passed by this honorable court, that is, Lordship will find at page 92. And party part, my lord, page 94. Details has been, my lord, given.
The other day you have shown this order to me.
Yes, that was the case. Now, the, my lord, we are aggrieved by the decision of the, my lord, so-called joint committee, that your Lordship will find page 101. How we are aggrieved, my lord. And party part, my lord, page 103. For a moment, my lord, just I'll finish, my lord. 103, Lordship will find
103.
103. Resolution number 6. We are aggrieved by this resolution. We are not entirely, my lord, affected. Nasir Mundal Memorial High so and so not provincialized earlier due to the late submission of the proposal under the provincialization of the Act 2017. Now, what is our role, my lord, in that matter, my lord? We have no role. It is your authority under the Act. Now, secondly, Lordship kindly see, there is no mention of date in the District Scrutiny Committee report, which is doubtful. Lordship has seen the very report. 16 to 2019. That was the date. Now in the annexer portion, my lord, there is no date. That is not our fault. It is the, my lord, state authority has to explain why date is not put in the annexer portion. We have no problem. Now, in view of this, my lord, situation, my lord, this impugned resolution is, my lord, purely without authority of law and, my lord, without application of minds, as, my lord, as evident from the available on record. So my respectful submission, this resolution number 6 has to be set aside and our services may kindly be, my lord, provincialized. That must be.
Lordship. Lordship, I have forgotten to submit one thing, Lordship. I have annexed an order passed by this honorable court, whereas this honorable court, under the similar facts and circumstances, Lordship, directed to provincialize the service at par with the other cases, Lordship. In that case, Lordship, it is 1/1/2021, Lordship. My case also covered under the same, Lordship. We have another 19, Lordship. That much.
Just one clarification, look, page 100, right?
Yes,
And Mr. Islam has read that this, the coordinate bench of this honorable court has gave a clear finding here. Whereas, Malad, he has not left the rest of the portion, where this honorable court has said that this is not decided. So, Malad, that's no, there is no ratio, Malad, decided when this.
Paragraph number?
Paragraph number 10. Paragraph number 10, he has just read the first 3 lines, Malad.
Page number?
Page 100.
Of his writ petition.
Yes, of his repetition, he relied on a finding of the coordinate bench of this honorable court to show that this honorable court has already held that the committee is a committee beyond the purview of the act. But he has read, my lord, paragraph 10, first 3 lines. However, in view of the provisions of the so 2000 Act, holds that the same committee is not a committee envisaged under the provisions of the Act of 2007. However, in view of the fact that in view of the present proceeding admitted the case of the petitioner not having been so recommended for provincialization on account of the fact that his name was projected in the recommendation of the state level committee erroneously. Now, my lord, can you mark this? The issue as to whether the inclusion of a joint committee in the process of scrutiny verification of the particulars of service of teachers of venture education would be mandated is not being examined in the present proceeding. The same would be examined in an appropriate proceeding in the future. So that issue has not been decided. Because there was no challenge with regard to the constitution of the joint committee, and therefore there was no argument advanced from both sides.
My submission is
Okay,
that this
okay.
honorable court failed.
One, my lord.
Another question is this page number 112. The second reconstitution of the committee, joint committee. Where the word secondary education is mentioned there. Terms and reference to the committee. Staff of Venture LP recognize UP and to ascertain whether the proposal are in accordance with the relevant provision of Assam Education, provincialization of service of teachers and reorganization of Educational Institution Act 2013 as amended up to date. How can this committee examine the recommendation of the secondary education?
The court earlier in the lordship finds 111. Earlier in the committee, there was only director of secondary education. Now, my lord, after the reconstitution, Director of Elementary Education was also inducted. Now, because of that fact, my lord, this woman, the serial number 1 in the terms and reference, but the rest, my lord, to obtain further information, clarification, if any, from competent authority and person of the educational institution, to obtain clarification from the appropriate authority on all information provided for provincialization of the service. So this remains same, my lord. This remains same. The 2 and 3. Now, if your lordship finds in the impugned resolution here also, my lord, here also the clarification has been asked for. Why the date was not there in the district scrutiny committee when it was sent to the state level committee in WPC number 6670. Similarly, in this petition also, my lord, the resolution says the committee has decided to verify the proper reason on how the enrollment data can be changed. So this is the clarification. This is the clarification, and below.
No, you see, Mr. Kaushik, you see, if the data is maintained by the Higher Secondary Education Council, what is the question of calling it from the SEBA?
No. Now, he has made confusing about this. Now, the Higher Secondary Education Council and the SEBA has a composite body which is known as ASAP. Therefore, it is referred to as ASAP report from the ASAP. Now, if your lordship find page 38, the school record. The school record against the subject history, no enrollment was shown. Page 38, my lord, you can see. Serial number 20 is the petitioner. Against the column history, my lord will see it is nil. No figures. Now, thereafter, my lord, a report by the controller of examination by the Assam Higher Secondary Council at page 41 says 11. Page 41. Director calls from the Assam Higher Secondary Council again by page 42. Page 43, it says again 10. Against history. So numbers are changing. School record says there was nil. The Higher Secondary Council first report says 11. Second report says 10. So therefore, my lord, the numbers have changed, and therefore the committee has decided to verify.
Why it is not there in the school record?
School record, Lordship, 38 and 39 is the type copy of page 40. Lordship, may kindly peruse page 40, vernacular one. It is there only, Lordship.
Even in page 40, my lord, you can see in the history, against the history column, here, my lord, serial number 20, Nath, in English 53, MIL 84, political science need, social science 59, economics 60, history need.
11.
No, where against the subject?
Last of grand total, Lordship. 11 is there, Lordship. Page 40, Lordship, is the vernacular one.
This is again doubtful.
If it is doubtful, Lordship, then
Against the
page
subject,
41,
against the
Lordship.
subject against all the candidates, numbers are written. Against this petitioner, numbers are not written. Down below, there is 2 numbers written. And who has put those figures? Don't find.
Lordship,
So these are the discrepancies, my lord, which the committee wanted to re-verify. There is no unreasonableness in doing that.
page 41, Lordship. Assam Higher Secondary Education Council, Controller of Examination. Page 41.
Yes.
And school record also maintained by the principal, Lordship.
This joint committee existed even in the earlier drive also. What my learned friend is saying, my lord, he is absolutely without any materials to show. This joint committee was constituted in 2019 when the provincialization process started pursuant to this sector. And this joint committee is nothing but a committee constituted by the government for undertaking the process of consideration as envisaged in section 13.
Okay.
One further one clarification, Milord. So for the notification is concerned, Milord, we are having the authority, Milord. Yes. Milord, I will not trouble your lordship, Milord, much. Just, Milord, we have referred the Milord judgment 2011 3 SCC, Milord. We have given the copy, Milord. Para, Milord, 59, 61, 62 and 63.
Paragraph number?
Yes, 59, 61, 62 and 63. That only 4 paragraph. 2011 3 SCC 436. State of Odisha versus Mamata Mahanti. It says any circular, any notification, any orders issued in violation of the statutory provision of the Act has nullity in the eye of law and it did not be challenged before the appropriate court of law. Court can itself set aside. That is the gist of the case. In the given case, the joint committee, whatever it may be, is beyond the statutory provision of the Act. So that notification itself, we need not challenge.
In which paragraph it is stated?
Paragraph 59, 61, 62, 63. Particularly 62, lordship will find. That's plus.
Part Mr. Mondal, learned counsel for the petitioner in WPC number. Uh, 6870 of 2025. And Mr. R. Islam, learned counsel for the petitioner in WPC number 6997. And Mr. D. Soikia, learned Advocate General cum Senior Advocate, assisted by Mr. Kosik, learned counsel for the respondent. Argument concluded. Judgment reserved.
Develop lordship.
Coming item 26 for admission.
May please the lordship. Lordship will kindly have a look. The last order of my lord 16/12/2025, my lord. I was directed, my lord, to submit the enrollment position of my school, my lord. After satisfying, my lord, regarding all the points and issues, my lord, the last point which was the lordship was supposed to, my lord, make a query, my lord, regarding the enrollment position of the school right from the year 2009 till 2016-17, my lord. And thereafter, my lord, on 3rd of my lord February, although it was, my lord, fixed on 27th of my lord January, this was
So
not
in the affidavit, you have brought on record the enrollment position since the year 2009, 2010 till 2016 and 17.
17, yes, my lord.
Okay.
I'll place it, my lord, very in a precise manner, my lord. I'll place it before your lordship, my lord. Lordship will kindly go to the running page of this affidavit, my lord, page 159. And this attendance register, my lord, this has been also verified and seen by the concerned authority. He is the sub-inspector of schools, who had also, my lord, issued the, my lord, inspection report in favor of my school, my lord. I, in fact, my lord, compared the inspection report along with the enrollment position of the school, my lord. It tallied, my lord. My lord will kindly go to page 159 of the, my lord, affidavit, my lord. This is the attendance register of the school for the year 2009, my lord. And right from the year, my lord, 2009, and from class 4 to class 1, my lord. 160 is the, my lord, class 1. And regarding the vernacular, my lord, if your lordship kindly turn to page 162, my lord, start, my lord. From class 4 to, and the next page, my lord, there is a, my lord, attendance, January 2009. 162 and 63, vernacular, my lord. For the year 2009, my lord. This is
Okay.
for class 4, 3, and 2, my lord. And regarding class 1, that is, my lord, will find at page 183 for the year 2009.
Okay, Mr. Fukan, you have received the copy?
Yes.
I have got the copy of the affidavit. My lord, yes, completed.
No, no. You have to complete.
No, he has already argued the matter at length on earlier occasion. He was only directed to file an affidavit to bring on record the enrollment position.
Exactly.
And he has already filed the affidavit.
Yes,
You have received the copy?
Yes, my lord, I have received a copy.
Okay.
And I have gone through the same, my lord. This is a particular affidavit bringing on record, my lord, of students' registers, my lord, which is handled by them. This is not a document of, my lord, if your lordship kindly sees page 113 of the Act. The Act says, my lord, the mandate is that the enrollment shall be verified with the data as per code of 2009 or before available as record as available in the records of the National University of Education, Planning and Administration, New Delhi. There shall be physical verification of students and checking of records of attendance of students last 3 years. Now, your lordship sees these particular, all these documents which is given, there is no verification. It is not done like that. There is a process, my lord, wherein DIAS data is maintained by the server SSA, Samagra Shiksha, my lord. And my lord, the Samagra Shiksha has, if the lordship again comes, it again boils down to the same point. Lordship comes to the affidavit which I had filed. There are two affidavits which I had filed. First affidavit which we had filed was where the court had asked, the honorable court had directed us basically to, the lordship comes to page 105. 105. It says by the director. The director, your lordship, after the court, honorable court's order, the court was asked to basically go and, my lord, carry out an inspection. My lord. So lordship comes to page 106, paragraph 3. Paragraph 3, page 106. In the first affidavit, we had categorically given, my lord, answering Lieutenant respectively state that the Honorable High Court passed an order dated 7/11/23 in WPC 3521 Azizul Haq versus so and so, with a direction to the DESM to depute an officer of a rank of higher than inspector to carry out an inspection of so and so, this schoolman, and take an appropriate decision on the claim of petition of a provincial life. During the time, there was no officer of the rank of joint secretary. Therefore, the government requested to depute one joint secretary from department of school to inspect the school. That is Dakhin Kodokmoni Pathar LP School under Pathadrama Education Block under in Nagar district. To comply with the honorable court's order. Accordingly, my lord, the government deputed so and so Sam and of the thing to carry out a spot inquiry of Dakhin Kadamani Pathar LP School located at the village Kadamani Pathar so and so. Though prior notice was given by the so and so. Kindly lordship come to the main thing, 109. That is the report. 109 Annex 1 is the report. With reference to subject cited above, I'm trying to state that pursuant to the Department of School, so the undersigned along with so and so had conducted spot inspection of Dakhin Kadamani that so and so. The honorable court in spot inquiry of the school, it is found that in spot inquiry, they went at 10 a.m. Accordingly, an inquiry of Dakhin Kadamani Pathar's DSP school was carried out on 29 January 20 at 10 a.m. 10 a.m. Went at 10 a.m.
No, already you have shown that.
These are old stories, my lord. These are settled, my lord. Very old stories, my lord. He's repeating all these things again and again, my lord. After this, unnecessary, my lord, submissions, my lord.
When he said I had not interrupted me. Then, my lord, after that, my lord, when the spot inquiry was done, made there, my lord, the students were not there, and my lord, there was nobody available in that particular thing.
Okay.
Thereafter, my lord, your lordship asked me to file another affidavit. My lord, bringing on record the view of the SSA, that is crucial. Thereafter, my lord, we have filed another affidavit bringing on record, wherein the affidavit of the my lord, lordship comes to the affidavit directly, my lord. Page 144. Relevant page 144 first, my lord. There, my lord, the claim of the petitioner for provincialization of services was rejected, as per report stated to have been submitted by SSA Assam. Because, my lord, SSA is the person who maintains the DIAS code. The DIAS code has to be, my lord, as per the Act. That is, Act says that the enrollment shall be verified by with the data as per Rule 311, 312. It has to be followed in this manner. He cannot, my lord, produce this particular service book, my lord. This particular service book.
No. He produced this as per direction of this court.
Exactly, he has produced this, but that does not tally with this, my lord, because the SSA
Maybe.
no enrollment.
We'll see later.
My lord. So this is the main thing, man.
My lord, I may be allowed to clarify, my lord, this point. Why my name was not included in the DIAS code, my lord?
No. You have already clarified on
Yes,
that
my
point.
lord.
Photos have been given, my lord.
Since there was a dispute, my lord.
Report is there.
Yes, my lord.
Okay.
Photos also are there. The school was, my lord, nobody was present. The teacher was not present.
These are all
Students not
stories.
present. And, my lord, they went there after.
Mr. Fukun, you have already argued on that point.
Yes, my lord.
Okay.
But the only thing is that, my lord, why, my lord, our name could not be, my lord, reflected in the subsequent DIAS code. And in this regard, the concerned authority, he is the district officer, my lord. He himself has written to the higher authorities saying that it is because of the earlier dispute of the other school. Our name could not be carried out. As such, he has requested the higher authority to issue afresh or to continue with the earlier DIAS code, my lord. And in this regard, the higher authorities remained silent, my lord. They did not do anything, my lord, in behalf of our school. This is the only reason, my lord, for which
151 and 152.
our school was not captured in New Palm, my lord.
DIAS data information is given there of the SSA.
Okay.
151, 152. Okay, no.
I've seen it.
There the whole thing will be clear.
Pardon, Mr. Ahmad, learned counsel for the petitioner. Mr. Fukun, learned standing counsel for the respondent in Elementary Education Department. Argument concluded, judgment reserved. Cover next item.
Item for hearing under Article 41.
I'm deeply obliged.
Number 5.
Lordship, only request before your lordship is the only humble prayer, my lord. Because, my lord, the school's name could not be continued in the DIAS code, for which, my lord, in the new form, my lord, national, my lord, DIAS data, my lord, our name could not be reflected because of the earlier dispute, my lord. In this regard, the crucial, my lord, point is the, my lord, the report of the direct, my lord, district officer, my lord. That your lordship will kindly consider, my lord. Deeply obliged.
May I please your lordship? In this matter, your lordship was please directed to, they have not yet appeared before the court by filing any Vokalatnama, your lordship. Our case is that, your lordship, the respondent has paid before the trial court by filing suit for declaration of their right, title, interest and first position and evicting us from the suit premises, your lordship, not suit land, suit premises, L type, Assam type house, your lordship. That is, your lordship. We have taken a substantial question of law, lordship. It is after index, your lordship. Substantial question of law. Lordship, I am taking your lordship to their plaint, your lordship. To their plaint, your lordship. That is in page number 13, lordship. 13. May I go through, lordship?
Yes.
And number 1, that the plaintiff is recorded patadar having right, title and interest thereon of a plot of land measuring 1 biga 2 kata 10 lesa covered by dag number so and so, periodic patta number so and so, situated at 101 number Grant, Maibela, Moja Silakuti, district Choraido. Plaintiff father Rajani Borthakur, since deceased, was an employee of Mathurapur Tea Estate, where he was allotted a company's quarter. The entire family of the plaintiff father, which includes his 4 sons, namely Sanjeev Bhattakur, plaintiff, the Rajiv Bhattakur, defendant, Pradeep Bhattakur since deceased, and the Pranab Bhattakur were resided in the aforesaid company's quarter. Number 2, Lordship, that being the eldest son, Rajani Bhattakur, on attaining majority, the plaintiff started to do contractual work with ASCB, Maibela since 1980. At that time, the plaintiff had occupied more or less 1.5 bigha land, dag number 46, part, and 101 grant by cleaning jungle and build a L pattern Assam type house thereon in the year 1981-82. Plaintiff father retired from the Mathurapur tea street in the year 84, and after his retirement, all members of the family settled to reside in the house built by plaintiff at 101 Grant. As company's quarter had to be vacated on the retirement of plaintiff father, the L pattern Assam type house having 5 rooms and separate latrine bathroom is standing upon an area of 0 bigha 1 kata 10 lusa out of 1 bigha 2 kata 10 lusa, bearing patta number 76, dag number 32, 132 new. More to be described in the schedule below in the subject matter of the suit. Number 3, that the plaintiff father Rajani Bhattakur expired in the year 1995. His second son, namely Rajiv Bhattakur, defendant, got married in the year 2000-2001. That is present appellant, your lordship. And he left the plaintiff's house along with his newly married wife in the year 2002 and started to live in a rented house. The third son of Rajani Bhattakur, namely Pradeep Bhattakur, expired in the year 2012. He was unmarried and psychiatric patient. The fourth youngest son, Rajani Bhattakur, namely Pranab Bhattakur, also left the plaintiff's house in the year 2004-5 and started to live permanently at Shivsagar. That Revenue Department of Govt of Assam started to collect land revenue, Toji Khazna, from plaintiff for the land he occupied since the year 1985. And later on, Govt of Assam allotted the land to the plaintiff in the year 2008, measuring 1 bigha, bearing dag number 46, part 101 grant under Silakuti Moja. Later on, in the year 2012, the competent authority of Govt of Assam issued annual Firaj Patta number so and so in the name of plaintiff for 1 bigha 2 kata 10 lesa land bearing dag number 132. This is the separate land, your lordship, 1 bigha 2 kata, which includes the suit land. And another plot of land
Mr. Dasgupta,
bearing dag number 122.
Mr. Dasgupta,
Lordship,
you come to your memo of appeal. Page number 3.
Lordship,
Page number 3 of your memo of appeal.
Lordship, Lordship,
So these are the grounds.
Lordship, and substantiation question in the other page, your lordship,
Which page?
prior to that page. After the index, lordship, substantial question of law.
After the index.
After the index, lordship.
No, you say.
Whether the learned court below have committed
Mr.
error,
Dasgupta,
lordship.
you see subsection 3 to section 100 CPC. CPC is with you. CPC is with you. See the subsection 3 to
Subsection
section
3.
100.
Enter. 100. By 100. Subsection 3. Here, what happened, your lordship? This present plaintiff, that is respondent, he fraudulently obtained the patta lordship for two plots of land. And in the year 2008, he left from this parental house with his family, leaving behind his ailing mother and the ailing brother, and lived separately from 2008 in that plot of land, 1 biga lordship.
Yes,
And he, yes, lordship. Punta 3. In appeal, under this section, the memorandum of appeal shall precisely state the substantial question of law involved in the appeal. Your lordship.
in your memo of appeal, where you have precisely mentioned the substantial question of law.
That is, lordship, after index, lordship. That's immediately after index page, lordship.
It should be in the memo of appeal.
Lordship, it is whether I have given 5 points, your lordship. 5 substantial questions.
No, you are not getting my point.
Lordship.
This substantial question of law should be incorporated in the memo of appeal itself
Lordship.
in terms of subsection 3 to section 100.
Lordship.
You have not incorporated it.
I have given in this question. Immediately after index page, we have incorporated that, your lordship.
No. This index space is not a part of the memo of
Lordship,
appeal.
that is, I know, lordship. That's a mistake I have committed, lordship.
So you file amended cost title law, we will say. Amended memo of appeal incorporating this substantial question of law. But Mr. Dasgupta, learned counsel for the appellate. Perusal of the memo of appeal,
Lordship,
indicates that as mandated by subsection 3 to section 100 CPC, substantial question of law has not been precisely stated in the memo of appeal. Rather, the same is enclosed in a law set before the memo of appeal. In view of above, it is provided that Mr. Dasgupta shall file amended memo of appeal incorporating the precisely mentioning the suggested substantial question of law in the same. List the matter after 1 week.
the date may be given, your lordship. Otherwise, very difficult.
6 March.
6 March. Obliged, lordship.
Timing item 6 for orders.
My lord, the dispute is regarding provincialization. Now,
This IA is for what purpose?
IA क्या था sir?
Okay.
My lord, the facts are like this. When my lord 2011 Act was in force, this dispute arose. Now, actually, at page number 24 of the writ petition,
Page number 24.
yes, my lord. Now, this was the recommendation of the district level selection committee. District level, Naidu. Pro forma information on provincialization of venture institution. Serial number 6 is the petitioner, my lord. And serial number 5 is respondent number 6. Now, the petitioner is BSc Royal, and my lord, respondent number 6, that is serial number 5, he is BSc Biology. Now, my lord, apparently, the respondent number 5, na? Azhar Ahmed 282. Azhar Ahmed 2, not na? Other side. And respondent number 5, my lord, apparently he was not recommended. Then, my lord, he filed a suit at page number 29, my lord. Now, if your lordship would kindly come to page 32, wherefrom his grievance can be noticed.
Yes.
Para 4. That surprisingly, sometimes in the last part of 12, the petitioner came to know from the education website of the Kamrup district that though he has been shown as assistant teacher science, but in the column he has been shown as an assistant excess teacher within the Boko LAC area, whereas two other science teachers, junior science teachers, namely Abdul Rasid Ahmed, that is serial number 5, my lord, of that page which I have shown, that is respondent number 6, and Raham Ali Ahmed petitioner were appointed only on 24/4/19 and 25/2/2006 respectively, yet they were shown as regular science teachers. After knowing this, he immediately brought the matter to the notice of the headmaster and also wrote a letter to the Director of Secondary Education Assam on 8/4/2013. And now, Lordship may kindly come to the next page, Miller, para 33. In this regard, it is worthy to mention that high school only 2 science teachers can be provincialized. But as there are 3 science teachers in Badla Rangapani High School, so senior most 2 science teachers have to be provincialized, and those 2 teachers would be the petitioner and respondent number 6 respectively. That after realizing that the petitioner has been shown as an excess teacher wrongly, the school authority, that is headmaster, wrote a letter to the inspector of school certifying that the petitioner is not an excess teacher, rather he is the senior most science teacher of the school. He has also been issued a certificate to that effect on 23/4/13. After receiving the letter from the headmaster, the inspector of school Kamrup district circle also wrote a letter on 30/4/2013 to the director of secondary education for re-examination of the services who was shown as excess teacher in the education website of the director's office. Now, therefore, the case which was made out by the respondent number 5 before the my lord this education tribunal was that under the scheme of 2011 Act, since there were 3 teachers, it is seniority that will govern the right, not subject combination. That was the case. And his case contention has been accepted, and his my lord reference to the tribunal was allowed. Now, my lord, what had happened, my lord? Lordship knows 2011 Act was repealed. And in its place, my lord, a new act came, that is in 2017. Now, the difficulty to accept the respondent number 5 petitioner's contention is, my lord, respondent 5 contention is, in view of the savings clause of the Act of 2017, nothing has been saved. That means, my lord, all what has been saved was whosoever services were provincialized under the 2011 Act, that too with a rider that those will be reviewed, whether they conform to the eligibility requirements prescribed in 2017 Act. That seniority would govern the field, my lord. That law, as if because of the repeal, in the absence of any savings, the consequence would be, my lord, as if that law was never there. So today, how can his right be agitated? That is the issue. Not only that, my lord, he could not have gone to the tribunal. First, my lord, let me raise my technical objection. If your lordship would kindly take this education code, my lord.
Yes.
If your lordships would kindly come to 2017 Act, which starts at page 99, I suppose. Yes. My lord will kindly come to section 14 first.
Yes, appellate authority.
Yes. So against the order of the district level scrutiny committee, he should have preferred an appeal to the state level scrutiny committee, which he has not done. Secondly, my lord, he have filed a suit. So please come to section 19. Section 19.2. Sorry, 19.1. No suit, prosecution, or legal proceeding shall lie for anything in good faith done under this act, except with the previous sanction of the state government. Section 19, subsection 1, my lord. So, my lord, apparently it's like 80 CPC, my lord. In 80 CPC, there is a relaxation clause. Here, there is none. So, it's a mandatory clause. So, if you want to invoke that power, then you have to obtain sanction. Admittedly, in the instant case, my lord, there is no sanction. Now, my lord will kindly come to the 2011 Act. Yes, 2011 Act is at page number 647. Please come to me, Lord, page 654, section 4, subsection 2. At page 654, somewhere in the middle.
Yes.
The number of employees in both teaching and non-teaching cadre in each of the venture educational institution, services of whom are provincialized or are to be provincialized under this act, shall not exceed as specified in the schedule appended thereto. This 2 million, there is no difficulty, science teacher. Provided that where the number of such employees serving in such venture educational institution exceeds the number as specified in the schedule, the provincialization of services of the employee shall be on the basis of seniority in the respective category in the concerned educational institution. State government shall not have any liability whatsoever in regard to such excess employees. So, my lord, if there are more than 2, then, my lord, based on seniority, that way his perspective was correct on that day. Had, my lord, 2011 Act been alive, then he is okay, my lord. He has got a legally enforceable right. But what would be the consequence of repeal of this act and without there being a savings clause? That's the only point. Now, my lord will kindly come to at page 99, 2017 Act. Please come to section 24. Now, my lord, the requirements are different. There is no such provision as seniority and all. So therefore, today, when your lordship is considering the case, so today it has to be decided in the light of the law which is holding the field today. The law which is holding the field is 2017 Act. And 2017 Act, my lord, the requirements are totally different. You have to comply with the requirement of RTI Act, then my lord, then section 4. If your lordship to kindly come to section 4, my lord. At page 114.
Yes.
Section 4, subsection 2. Teachers and or tutors to be provincialized under this act must have been working as a teacher in the concerned venture education institution as mentioned in section 3(1)(i) that have been recognized by the competent authority, must have minimum educational and professional qualification as laid down under different acts, rules, and kindly mark this word regulation, my lord. As mentioned under section 6 of the so-and-so, must have rendered at least 6 years of continuous service as on 1/1/17. So, my lord, today to claim provincialization, these are the requirements which are to be met. The provision like seniority is no longer there in 2017 Act. Now, section 6 also, my lord. The services of teacher in a venture educational institution from the primary level to degree level shall be considered for provincialization in the post of teacher or relevant teaching faculty in appropriate nomenclature as the case may be, subject to fulfillment of the eligibility criteria relating to educational and professional qualification as laid down under the following acts and rules. Right of children to free and compulsory education, National Council for Teachers Education Act, Assam Secondary Education Provincialized Service Rule, UGC, etc., etc. Now, my lord, will kindly come to 24, which in my humble submission is decisive in this case. The Assam Venture Educational Institution Provincialization of Service Act 211, as amended by Assam Venture Educational Institution Amendment Act 2012 and the Assam Venture Educational Institution Provincialization of Service Amendment Act 2013, which have been struck down by the Honorable Gauhati High Court by order dated in WPC number so and so. Now, this is important. And all rules, orders, notifications issued thereunder shall stand repealed. However, all the teachers whose services were provincialized prior to 23/9/16 shall continue and their cases shall be reviewed as per eligibility norms set forth for the provincialization under this act. So normally in a repealing and savings clause, what is contained is what is revealed and what is saved. Now, what has been expressly saved in this case is those provincialization orders which were passed under the 2011 Act, that too which are either shall contain the case reviewed as per. That means, my lord, those whose services were provincialized under 211 Act, their cases will be reviewed having regard to the qualification and eligibility requirement prescribed under the 2017 Act, and that on that further orders will be passed. So other than that, my lord, nothing has been saved. In that view of the matter, my lord, my humble submission is they cannot hesitate this claim now. My lord, when a statute is repealed, my humble understanding is, my lord, as if that statute was never in force. Yes, the legislature has the power to, my lord, save. As legislature has power to repeal, legislature also has the power to save. But what has been saved is only the provincialization orders. Now, in such a scenario, my lord, how to reconcile the right of the respondent number 5 petitioner before the tribunal? That is the issue, my lord.
But there are some decision of the Supreme Court.
Yes,
that the right that
Which
arose
account-
in earlier acts
Huh.
that will not extinguish even after a repeal of the.
No, my lord, that can be saved.
Mm,
That can be saved provided it is expressly done.
mm,
What has been done here is, my lord, only the provincialization orders.
mm.
No, my lord, matter is very simple. If the intention of the legislature was to save the cases which were for, in that case, my lord, there are so many other cases which are, my lord, if even I file a, for example, my lord, the division bench cases, that argument of mine has been rejected by the division bench. My lord, what had happened under the 2011 Act, in batches, provincialization was done. Now, some teachers were left out. Now they have been appointed as tutor because they do not have qualification in terms of the 2017 Act. Now, my lord, why it is more important? Please come to this provision. If your lordship would kindly come to section 4 for a moment. Sorry, section 6, subsection 2.
Yes.
These services of a teaching employee in a venture educational institution shall be considered for provincialization as teachers only if they have the requisite academic and professional qualification prescribed under the relevant act, rules and regulations as mentioned in subsection 1 of this section, which are applicable for the time being in force. Otherwise, their services will be provincialized as a tutor. That means, my lord, even the 2017 Act envisages a situation where the people who were working under the earlier regime, my lord, they do not have the qualification as per section 6(1). So their services can be regularized not as a teacher, but as a tutor. There's a huge difference between a teacher and a tutor. Now, my lord, our case, which we agitated before the division bench of this honorable court, was, in fact, we put to challenge some of the provisions of this act, my lord. Now, there our contention was that our rights has been saved, which was rejected expressly. Division bench judgment, my lord. Precisely on the same very point, we said a batch was provincialized under 2011 Act. Our cases were being processed. At was that point of time, my lord, the law officer of the state made a statement before the court that this law is bad. We are going to repeal it. So it was done, my lord. Now then we said, then our rights survive. It said it has been by application of section 6(c) of the General Clauses Act, it survives. This argument has been not accepted, my lord.
But there are several judgments.
You know, there are judgments of the Supreme Court,
Yes.
where the Honorable Supreme Court has said what can be saved, what cannot be saved. If your lordship wants, I can place all those judgments, my lord. There are 2-3 very important judgments on this point. But because the language of section 24 is so clear, I thought the judgments may not be required. Because, my lord, something has been saved. What is that something? The orders of provincializations subject to rider. Other than that, nothing has been saved. Now, my lord, if this line would not have been there, for example, if your lordship kindly comes to section 24 for a moment, my lord.
Yes.
Now I am reading the last 5 sentences, my lord, which have been struck down by the Honorable High Court by order dated 23/9/16 in WPC number 3190 of 12, and all the rules, orders, notifications issued thereunder shall stand repealed. All orders mean, my lord, an order which was passed earlier under the 2011 Act. However, all teachers whose services were provincialized prior to 23/9/16, that is the date of coming into force of 17 Act, shall continue and their cases shall be reviewed. So, my lord, if this last sentence, my lord, from however would not have been there, then, my lord, General Clauses Act section 6(c) would have come into play.
Otherwise,
Even otherwise not. Even, my lord, that argument of ours has been rejected by the division bench. Because it's a case of express, my lord, savings. A part has been saved, others have not been saved. So today, my lord, with the right which accrued under 2011 Act, how can it can be enforced in a court of law, my lord? So that is the case, my lord. And there, even my cases, if today is to be considered, then it has to be considered under the 2017 Act. So, my lord, the educational tribunal has erred in law, my lord, in not appreciating the meaning of 24. If your lordship wants to, I can place those judgments, my lord, when it can be said, even assuming, my lord, that this sentence is not there, then how, what is a vested right? When can it be said that it has been saved? Though there are 2-3 judgments, I can place it, my lord. Otherwise, broadly, this is my submission, my lord, because it's a clear case of repealing and savings. Sometimes, my lord, statute contains repealing provisions alone without any saving clause. Then General Clauses Act will come. Please have section General Clauses Act for a moment, my lord.
General clauses.
Please come to section 6, my lord.
Yes, effect of repeal.
Yes. Where this act or any central act or regulation made after commencement of this act repeals any enactment hitherto made or hereafter to be made, then unless a different intention appears, the repeal shall not come to see, affect any right, privilege, obligation, or liability acquired, accrued, or incurred under any enactment so repealed. So, my lord, a different intention has been expressed of saving only orders of provincialization.
No, intention can be inferred from where? From the statement, object, and reason of the act, or from the repeal provision?
When it comes to deriving the intention of the statute, it can be from the many things. It can be from the preamble, because the objects of the act is also important. Then the relevant section, whatever meaning is given, all the statute taken as a whole. Now, what I am trying to submit for your lordship's kind consideration is, when a legislature has repealed at the same time saved also certain provisions, then can it be said that section 6C of general clauses will apply? My humble submission, my understanding is, Lord, it cannot. Because the language is, unless a different intention appears. The intention has been expressed to save only the provincialization orders, that too with a rider. So therefore, my lord, there is nothing to, enforce qua the respondent number 5's right. In any case, my lord, there are other infirmities. The reference to the tribunal was without taking sanction of the state government. And my lord, now kindly come to merits of the case. Now, if your lordship will kindly see, come to page number 113.
Yes.
Now, this is a regulation by SEBA, my lord. Please come to left-hand side top, Roman 2. The subject combination of BSc teachers shall be such that all BSc teachers taken together shall cover 6 weekly periods in mathematics, 2 periods in physics, 2 periods in chemistry, and 2 periods in biology per section. I am repeating, my lord, the subject combination of BSc teachers shall be such that all BSc teachers taken together shall cover 6 weekly periods in mathematics, 2 periods in physics, 2 periods in chemistry, and 2 periods in biology per section. Then, my lord, will kindly come to the next page, my lord, right hand side, 5 towards the bottom of the page. BSc teachers shall be so selected that their subject combination cover all branches of science and mathematics. Now, my lord, the position is, if respondent number 5 is to be, I've given, my lord, I have given the, now, my lord, petitioner is a royal, so he has got physics, mathematics, chemistry. Then respondent number 6 has, my lord, botany, zoology, and maths. And respondent number 5 have maths, chemistry, and zoology. So, my lord, if respondent number 5 and 6 are to be appointed, then, my lord, students will be deprived of teachers to teach physics and biology. That is why his name was not recommended. Because in the event both of them are to be, services are to be provincialized, then there is nobody to teach physics and biology, which will go against the SEBA circular. Now, my lord, there is a judgment of our High Court, even of a division bench, that this is not relevant, its seniority has to go. But, my lord, in those judgments, these aspects were not gone into. In any case, my lord, those 2 judgments are under the 2011 Act. We are no longer concerned with that. Now, the eligibility has to be reckoned having regard to the 2017 Act. Therefore, my lord, those 2 judgments lost its efficacy in deciding the present list. because we are no longer covered by 2011 Act. Yes, there is a judgment, my lord. One Honorable Justice Ujjal Bhuiya had delivered one judgment, then that there is a DB judgment also, where it says that while recommending name for provincialization, seniority has to be
Concrete.
yes, has to be given due deference. But my lord, now the situation has changed. So any claim for provincialization of under Act of 2011 has not been saved. So therefore now the eligibility has to be adjusted from the point of view of 2017 Act. That being the position, my lord, my humble submission is the order of the tribunal is a nullity, my lord, because tribunal has also dealt with that point only at page 106, my lord, or 105. The subpara. Hence, it is decided that the plaintiff petitioner is senior-most teacher of Badla Rangapani High School among the 3 science graduate teachers whose names were entered in dice code for the year so and so. In this context, the respondent number 7 during argument has submitted that as per SEBA regulation, BSc teacher has to be so selected that their subject combination cover all major branches of science and mathematics. And the respondent number 7 is a science teacher who is having physics, chemistry, and mathematics, whereas petitioner is having mathematics, chemistry, and zoology. And respondent number 6, the respondent number 5, is having mathematics and zoology. So therefore, my lord, both of them that cannot teach, my lord, biology. They cannot, perhaps in that case, they cannot teach physics and biology. Therefore, it is the submitted on behalf of respondent number 7 that if the petitioner and respondent number 6 are appointed as subject teachers, science teachers, then who will teach physics in the school? And in view of above position, mere seniority cannot be a ground for provincialization. Rather, inclusion of respondent number 7 as a science teacher is not only justified but necessary for running the school, and therefore the authority has rightly included respondent number 7 and not included the petitioner who is kept as an excess teacher. So, my lord, as the law was prevailing on that date, perhaps, my lord, the judgment is not to be faulted, because the 2 other judgments were holding the field, which they, my lord, referred to the next page. After going through the said judgment, I am of the opinion that said judgment is not applicable to support the submission of the learned counsel for respondent. Now, this is important. On the other hand, the petitioner side had relied upon a decision of the Honorable Gauhati High Court, passed in Syed Sahidul Islam and 9 others in WPC, wherein the Honorable Gauhati High Court in a similar case was pleased to hold that for the purpose of provincialization of services of teacher, it will be as per the Act considering their seniority. So those 2 judgments were relied upon. But anyway, my lord, now things have changed. Therefore, my humble submission is, my lord, in today's context, when today Lordship is considering this matter, my lord, today Lordships will go by the 2017 Act, because the earlier provision is no longer in existence. When an act is repealed, the consequence is as if it never existed. That's my position. If a Lordship wants, I can place those 2 judgments, my lord, on how to decide whether what is a vested right, what has been saved, what has not been saved. If a Lordship wants, I can place those judgments.
Tomorrow morning you can submit it.
My lord. If not tomorrow, day after tomorrow, certainly.
Yes.
Meet with the lordship. Just 2-3 facts and just enlighten your lordships.
The Lordship's kind permission, one matter is coming up.
The petitioner was initially appointed on 25/2/2006.
25?
2006. And the respondent number 5, that is whom I am representing,
He was initially appointed on 12/9/1996. So it is an admitted factual position, and it has been proved before the educational tribunal that the respondent number 5 is much senior than the petitioner, my lord. So there is no iota of doubt with regard to that. They failed to disprove this fact, my lord, before the tribunal. Now, to understand, there are another one more fact, my lord. When the petitioner's name was not included in the list, he filed a writ petition before this honorable court. That is WPC number 2913/2013.
Yes.
In pursuance to direction of this honorable court in WPC 2913/2013, the petitioner had approached the education tribunal for determination of seniority of, respondent number 5 approach for determination of seniority of petitioner vis-a-vis the respondent number 5. So it was not the case that the respondent number 5 filed a title suit directly before the learned tribunal. Pursuant to an order passed in a writ petition, they were relegated to the learned tribunal for determination of seniority.
No, that's all right. But are you not supposed to consider the other aspects?
Yes.
Regarding obtaining permission from the government?
To that, Milo.
Yes.
I'm coming to that, Milo. So these two facts are, Milo, my learned senior Milo did not, it was not presented. So I'll just enlighten you with these facts, Milo. Next, the most important document in the present proceeding is the order of provincialization. That Milo will find page 164 of the affidavit. So this is a provincialization order.
164.
164 and it's H of the affidavit. Affidavit in opposition filed by respondent number 5.
Yes.
This is the provincialization order of 2013, my lord. It says order in pursuance of the government letter number so and so dated 25/7/2013, whereby 870 numbers of teaching and non-teaching staff have been created. Now, this is important, have been created for Kamrup Rural District under provisions of the Assam Venture Educational Institution Provincialization Service Act 2011 as amended. The undermentioned posts are hereby allotted to Badla Rongapani High School, District Kamrup Rural, with effect from 1/1/2013, which was recognized on 1/1/1996. Now, serial number 3, graduate teacher, science, 2 posts. Posts were already created under the Act of 2011 and provincialization order has been issued. Now, let us understand this order from the purview of the Act of 2011. Now, if your lordship kindly take the 2011 Act, what it provides, because my submission would be, my lord, I don't at all come under the 2017 Act. So the provisions referred to by the petitioner, section 24, section 19, are not at all applicable in my case. Since my provincialization was already done under the 2011 Act, so I no longer come under 2017 Act. Let us, my lord, see section 4. Of 2011 Act.
Yes, employees to be government servant.
Employees to be government servant. 4.1. The services of the employees of all eligible venture educational institutions under section 3 shall be deemed to have been, Lordship will kindly mark, shall be deemed to have been provincialized on the date of coming into force of this act, and they shall become employees of the state government with effect from the date, from that date, provided such institutions have completed at least 7 years of imparting education from the date of affiliation, recognition, concurrence, or permission, as the case may be, as on the date of coming into force of this act. Now, section 4.1 provides that all the employees who were in service as on that date, that is the date of coming of the act, they will be deemed to be provincialized. So there is a legal fiction that whoever was there on the date of coming of the act, their services will be deemed to be provincialized. So the moment this page 164 notification is issued, provincializing the school, the employees, their services were deemed to be provincialized. Now, let us go one step ahead, my lord. What section 4.2 says? The numbers of employees in both teaching and non-teaching cadre in each of the venture educational institutions, services of whom are provincialized or to be provincialized under this act, shall not exceed as specified in schedule appended to this act, provided that where the number of such employees serving in such venture educational institutions exceeds the number as specified in the schedule, the provincialization of the services of the employee shall be on the basis of seniority in the respective category in the concerned educational institution. Now, as per the 2011 Act, the criteria is the seniority. Whoever is the senior, he will be provincialized. Now, section 10 4. This is the process started from section 4.1 and section 10 is the last process, after which, pursuant to which the notification issued for provincialization. So my submission would be, once the notification of provincialization is issued, the entire provincialization process of the staff in the school is over under the 2011 Act. So now section 10, if your lordships kindly see the process that has been provided, District Scrutiny Committee. I'm referring to section 10.4. The District Scrutiny Committee shall forward the verified list of eligible teachers school-wise in accordance with the number of posts specified in the schedule appended to this act to the concerned director, who shall, after making such further scrutiny as may be required, shall forward the same to the concerned department of the state government for consideration and for issuing notification in respect of the eligible institutions and employees eligible for getting their services provincialized. So when I gone through this process, my case gone through this process, and page 164 notification is issued under the 2011 Act. Now the consequence which remain is the posting order. If we, my lord, draw an analogy like promotion and posting, my promotion has already been effectuated. As because some person has challenged the posting order, the posting order remains. That doesn't mean that my promotion was illegal or promotion will not be sustained. So the moment 164 notification is issued, the entire provincialization process pertaining to that school, the staff of the school is over. As because there was a litigation with regard to dispute pertaining to seniority position, the posting order did not come. And educational tribunal has determined that issue, who is senior. and they failed to disprove the fact that the respondent number 5 was senior. Now, the natural corollary is that since provincialization order has already been issued under the Act of 2011, there cannot be another provincialization. So my case has to relate back to the effective date of this provincialization order. That is, my lord, 1/1/2013. The reason for making this submission is that, my lord, my case doesn't fall under the Act of 2017. It is purely within the purview of Act of 2011. My provincialization regularization process was already over under 2011 Act. So the contention of the petitioner that 2017 Act will guide the provincialization process is, my lord, absolutely incorrect. Now, my lord, to buttress this argument, my lord, I have a judgment of this honorable court itself, wherein an identical issue came up for consideration, and this honorable court has decided para 6 onwards. May I read, my lord? As already noticed, Section 4(1) of the Act of 2011 provided that the services of the employees of the eligible venture educational institutions shall be deemed to have been provincialized from the date on which the Act came into force, and from such date they become employees of the state government. The only requirement to be satisfied for such deemed provincialization is provided under proviso to Section 4(2), i.e., the number of such employees serving in the venture educational institution should not exceed the number specified in the schedule to the Act. In other words, a conjoint reading of Section 4(1) and proviso to Section 4(2) would lead to a conclusion that in the event an employee of an eligible venture education institution is within the permissible numbers prescribed in the schedule to the Act, the service of such employees to provincialized under Section 4(1) of the Act of 2011 from the given date of operation of law. Section 10(2) of the Act of 2011 further provided that in order to arrive at a conclusion as to whether an employee is within the permissible numbers prescribed in the schedule to the Act of 2011, the District Scrutiny Committee shall forward the verified list of eligible teachers in accordance with the number of posts specified in the schedule to the concerned director, who shall, after making further scrutiny, forward it to the Department of State Government for consideration for issuing notification in respect of the eligible institutions and employees eligible for getting their service provincialized. Now, this is important. Section 10(2) merely provided for a procedure to be adopted by the authorities in determining whether a given employee comes within the purview of the number of posts specified in the schedule, and such process does not in any manner require the state government authorities to take an administrative decision as to whether the given employee is to be provincialized or not. As already noticed earlier, the service of the concerned employees to provincialized by operation of law under Section 4(1) of the Act of 2011 itself. And there is no requirement of the authorities in the administrative side to further provincialize the service of the given employee. The provision of Section 10(4) is merely for providing a procedure to be followed by the authorities in arriving at its conclusion as to whether the given employee is within the permissible numbers as provided in the schedule. In the event the authorities pursuant to such process arrived at the conclusion that the concerned employee is within the permissible number as provided in the schedule, there is no further requirement of issuing any administrative order for provincializing the service of the concerned employee, inasmuch as his service already stood provincialized by operation of law under Section 4(1) of the Act of 2011. Any such order that the authorities may pass would be only in the nature of an order recognizing the provincialization of the concerned employee, which has already taken place by operation of law, and such order of recognition cannot be construed to be an order provincializing his service. It is an admitted position that upon verification of the number of employees, the Pochim Gauhati Mahavidyalaya, the authorities arrived at the conclusion as per Annexure 5, page 16 statement that the petitioner within the permissible number as provided in the schedule so and so. Once this conclusion is arrived at by the authorities, there is no further requirement of issuing any order to provincialize the service of the petitioner in as much as his service stood provincialized by operation of law under section 4(1) of the Act. In the present case, some other dissatisfied employees of the college had assailed the statement showing the inclusion of the petitioner within the numbers provided in the schedule, which upon being assailed was initially stayed by this court by order dated so and so in WPC so and so, but subsequently by the order dated 1/9/2016, the interim order so passed to vacated, meaning thereby the statement including the name of the petitioner within the number specified in the schedule stood as it was. Now this is important. A stand has been taken by the authorities in the higher education department that by the judgment and order dated so and so in WBC number so and so, the Act of 2011 was declared to be ultra virus. According to the learned Standing Council for Higher Education Department, it is the view of the department that as the Act had already been declared ultra virus, therefore no further order for provincialization of the petitioner can be effected by the department. It is taken note of that although the judgment and order dated so and so in WBC so and so, the Act of 2011 was declared to be ultra virus, but a subsequent decision dated so and so in review petition number so and so, it had been provided that the rights of the employees who have been benefited under the struck down statute can be taken care of by giving retrospective effect to the proposed legislation. If the legislature so decides, until then, the services of the provincialized category and their status as a government employee shall not be disturbed, and they will continue to receive all the benefit which they are getting under the Provincialization Act of 2011. In the instant case, as already concluded herein above, the petitioner being included within the number specified in the schedule, and there being no other impediment, his service to provincialize by operation of law under section 4(1) of the Act of 2011. Therefore, the case of the petitioner would be also be covered by the provisions of the paragraph 19 of the decision of the division bench of this court in so and so in review petition number so and so, and the benefit of provincialization that accrued to him by operation of law shall remain. In view of the above, the service of the petitioner to provincialize under section so and so, the court is of the view that there is no requirement of any further administrative order by the department to provincialize his service, and all that is required is to recognize that his service already should provincialize under section so and so in the facts and circumstances of the case. So in my humble submission, one way I can submit before your lordships that 2017 Act doesn't apply to me. Even assuming whatever the submission has been made by the petitioner, even assuming that the submissions are correct, my service has been provincialized in 2013 itself. So section 24, what has been saved, I am included. So in both ways, my lord, I am saved. If I argue before your lordship that 2017 Act is not applicable, then also I am saved. If I argue that 2017 Act is applicable, section 24 is applicable, section 24 saving clause saved me because of the fact that my provincialization had already happened. The petitioner are contemplating a situation that there will be provincialization order of the school, then there will be individual provincialization orders. That is not the contemplation under the Act. Act says it is deemed to be provincialized. Section 4(1). So in my humble submission, my lord, this I am squarely saved by in both the situations, my lord. Now, my lord, the next contention is that this is regarding section 24 of the Act saying that, sorry, my lord, section 19.
Suits and proceeding.
Yes, my lord, suits and proceeding.
Without previous sanction of the state government.
Yes, and my lord, what I have understood, my lord, although I haven't done many civil matters, my lord, but I have understood this proceeding, if this is relatable to ATCPC. In ATCPC, it is a protection to the state government.
Hmm.
It doesn't lie in the mouth of a third party that government was not given notice. So you decide in my favor. I have a judgment to that effect, my lord, of division bench. 1978 AP 38 AR 1978 AP 389. I'm just giving the copy, my lord. So you cannot take benefit. And the most important aspect is that in the written statement before the tribunal, this issue was never raised. Page 54 of the writ petition, my lord will kindly have a look. This was the written statement filed before learned tribunal. But I'll finish off in 5 minutes, my lord. Page 54. Para 1. Not a single whisper in the written statement with regard to this provisions of section 19.
Yes.
Lordship got page Annex of 5, page
Yes.
54. Page 54, Annex of 5. That before presenting his defense as to the averment so made by the plaintiff, the respondent respectfully state that the petitioner herein has got no lucus standi to edit the matter before this tribunal, in view of which the suit is not maintainable in the present state of facts and the law, as well as hence the same is liable to be dismissed. That apart, the cause of action, the relief as sought for in the suit is arising out of Assam Venture Education Institutions Provincialization of Service Act 2011 as amended in 2012. The said act has already been struck down by the division bench of the High Court in so and so. Therefore, the cause of action is no more in force. Moreover, as per the Assam Education Provincialization Service Teachers Organization Act 2017 has already been enacted, and the process for provincialization of existing teachers and non-teaching staff, including the left-out candidates, have already ensued and not finalized. In that view of the matter, the present suit in its present form, it should have been, is premature and as such not maintainable in the eye of law as no cause of action. under the
Okay,
Act of
okay.
2007.
No play was taken in
No
the
plea
written
was taken,
statement.
not a
That's
simple
it.
whisper.
Okay.
And if you'll also
Okay.
kindly consider, consider
And-
my judgment,
According to you, being a third party, he cannot take such a play.
it cannot. You cannot take. This is what the Lord this
Decision says.
High Court judgment
Yes.
has dealt in detail. Para 21 to 26, my lord. And if the government doesn't raise any objection in their written statement, that is relinquishing. That has also has been discussed here. Assuming tomorrow the government raises an objection, saying that you did not give me notice. If the government do not urge this ground in the written statement, then the Honorable Court has said that you have relinquished. You cannot reopen it again in the next forum. The right under ATCPC, you have relinquished your right. So that is precisely what has been held in para 20, 21, 22, 23, 24, 25, and 26.
Okay.
And my last clarification, Miller, I know Miller.
Mm.
Regarding this repeal, that issue has already been settled by this honorable court in Mohar Ali Miller. 2024 5 GLT 689.
Mm.
The relevant paragraphs will be 144, 145, 146, and 147. The submissions which were made by the petitioner will not pass the test of the scrutiny of this court under these paragraphs.
Mm.
Para 144
Mm.
to 145. 147, Milord. Just one paragraph I am reading, Milord. It would be relevant to mention here in that section 24 of the Act of 2017, which is the repealing provisions of the Act of 2011, does not lay down that the rights and privileges that had accrued upon the venture educational institutions under the Act of 2011 would stand extinguished with retrospective effect. Rather, Section 24 protects all action taken for provincialization of service of teachers prior to so and so. Such action in our considered opinion would also mean and include actions taken by the departmental authority in processing the application submitted by the respective venture institutions prior to so and so, seeking permission, affiliation, permission occur concurrence, as well as the decisions and recommendation of the district scrutiny committee, if any, recommending provincialization of the service of the teaching and non-teaching staff of the different venture education institutions. We are of the view that those employees in whose favor recommendations were made by the district scrutiny committee had a vested right for their claims to be taken to its logical conclusion under the Act of 2011. As such vested right of those employees could not have been taken away by the subsequent enactment of Act of 2017. Now, next para, Lordship will kindly have a look, para 145, 46, and 47. So this is the law holding the field with regard to section 24 repeal and saving. This is how the division bench has interpreted. And this has gone to Supreme Court, and Supreme Court also has affirmed this decision. With regard to some music teachers, it has went to Supreme Court. Honorable Supreme Court granted the benefit to music teachers also, the provincialization benefit. So, if this is the legal,
Whether this decision was challenged before the Supreme Court?
no,
This was.
in this particular
This
decision,
division bench decision was challenged.
In this particular decision, there were some category of teachers, music teachers.
Mm.
Those were not given the benefit.
Mm.
So they went to Supreme Court.
Mm.
And Honorable Apex Courts held that those music teachers are also entitled to the same benefit as has been granted by this judgment to other similarly situated persons.
That decision is available with you.
Yes, Milord. I'll provide.
Pardon.
I'll just, Milord, I'll give a copy, Milord. A recent decision with regard to the music teachers. So
Okay.
my humble submission, in none of the Milord, arguments advanced by the petitioner, Milord, can test the validity of this law.
Mm.
The legal position is absolutely clear. Anticipation of this, you cannot have a claim and say before the court that, look, state was not given an opportunity, so judgment went against me. So in that view of the matter, the judgment is wrong, Milord. Because I don't subscribe to this proposition. It's absolutely erroneous proposition. And the correct proposition of law, Lordship will find in the judgment which I have placed. So for its repeal is concerned, my first submission, 2017 Act, I doesn't come. Even assuming you take the respondent of 5 to be within the purview of 17 Act, then also I am saved by virtue of the judgment of Dilip Das and section 441 of the Act of 2011. Milord.
Okay.
So in my humble submission, writ petition doesn't have any merit. It has to be dismissed. My service has to be provincialized. Milord. I'm waiting since 2013. I'm sorry, Milord, for the.
No problem, no problem. Yes, Mr. Das.
Section 4.1 of the government covers the case of the proceeding.
Section 4.1.
My name was also recommended wrong back in 2013.
Okay.
And also, I have also given the judgment also, my written argument is also there.
You have filed a written
My
argument.
case is also security covered by Dilip Das judgment also.
Okay, you have filed your written argument here.
Yes, sir. Along with the argument also, I have filed my, I have given some judgment also.
Okay,
Because my learned brother has given judgment regarding subject combination.
Combination.
Those division bench judgment.
Subsequent to law.
An argument was raised that subject combination is not there. That has been already been settled below by division bench of this court as well as single bench. Those judgment my senior brother has placed before you.
okay, all right.
I am not reiterating those below. It's already there.
Okay.
Much of that. below.
In
Deeply.
rest of the cases, that may be taken from the court master.
Lord, I'm sincerely apologetic for
No,
that.
no, no, no,
Well,
no problem.
Much of it.
Later,